Yes, sir.
Please, Your Lordship. Lordship, I beg to mention item number 6 with regard to item number 6, Your Lordship.
Item number 6.
Yes, I may be permitted to call the additional affidavit today we have filed.
Hmm?
I filed an additional affidavit today. I may be allowed to call the matter,
What affidavit?
this is regarded, we have settled the matter. So we
You have settled the
yes.
matter.
So I have the agreement which we have signed, both the parties, that we have to bring it by way of additional affidavit.
It's a decree.
Yes, it was, the decree was challenged here. Then
Take
ultimately,
take it up tomorrow.
uh,
We'll take it up tomorrow.
tomorrow, Lordship, I have come from Guwahati.
We'll see. Call for them.
Please, Your Lordship.
Malad, may I mention item number 11, Malad?
11.
Yes, Malad. Malad, this has been wrongly mentioned in the admission column, Malad. It should be, Malad, in the order column, Malad. We have to file affidavit, Malad.
Yes.
Yes, they have to file affidavit, my lord. They may take time, my lord. My only thing is that the interim order passed on 27/3/24 may be continued.
Heard Mr.
M. Biswas.
M. Biswas, learned counsel for the petitioner. Last time you didn't appear.
My lord, what happened, my lord? No,
M.
it was,
Yes.
my lord.
Mr. M. Kato learned DSJ. Press for is granted 4 weeks
4 weeks
time
time,
to file affidavit in opposition. Interim order passed on
27/3/2024.
27/3/2024. Shall continue.
My lord, the interim order maybe till further orders, my lord, because my lord, every time, my lord, will have to mention. For
Don't ask everything at a time.
I'm obliged. Interim order date is 27/3.
My Lordship.
Yes.
Lordship, I'd like to mention two unlisted items for tomorrow.
What is the urgency?
Lordship, it's been more than 4 months, 4 weeks, the last occasion. This
Have you seen there are matters pending since 2015?
Lordship.
What is the urgency?
Lordship, the matter is pertaining to land matter and another one is for
Bail matter,
land matter.
land matter.
Land matter for final hearing and for another for POXO for bail hearing.
Hmm?
Another item is for POXO bail hearing, Lordship.
Why? It is listed.
Lordship? No, for tomorrow, Lordship.
Okay, you are filing a press petition.
No, Lordship, it's been 4.
It's already pending.
Yes.
It will come its own turn
Lordship, may kindly take up for tomorrow.
next week. POXO, bail matter and land matter.
Lordship.
POXO, forget it. It will be detrimental for you to list this, your case before this court.
Lordship.
So next week. Land matter on its own turn. Any urgency in the land matter?
Lordship.
What is the urgency?
Lordship, it's been already been 4 weeks that on the last.
Listed, don't worry. It will, it's on own turn. It will be listed. Already 4 weeks.
Lordship.
Maybe it will be listed tomorrow or day after, or maybe next week. It will be listed. No, you don't have to mention.
Lordship, obliged.
Yes.
My lord, I'd like to mention item number 30.
13.
30.
30.
Yes, we have taken the consent from the opposite party. Kindly it may be adjourned for today.
What remains there? Who is appearing for the state? You are supposed to place on record the original records. Record is there. It's in the selection process of 2015 or 16.
2002.
2002.
Two.
Oh, claiming for seniority and challenging the seniority list.
Yes.
It's of which year? Seniority list?
Seniority is of one is of 2009 and then 2013.
13. Things might have settled down by now. Any information, any instruction?
Instruction is just status is on today. Okay. Same only.
We'll take up 2015 matter.
My lord, today the matter is fixed for supplementing hearing. Leading counsel is out of station. It's not available today.
So on that ground, we'll not adjourn. Why is he out of station?
My lord, his name is also reflected in the absence cause list also.
Again, that's another ground which you will not adjourn.
My lord, kindly on the next date, he will definitely be present.
Give the file to him. We'll dispose of. You take the second file and read it. We'll take it at the last item. You take the file, second file and read it. And argue the matter. Yes, next.
May I please, Lordship,
Yes.
I beg to mention item number 8 and 9.
8 and 9.
On behalf of KLO leading counsel for the respondent. He is out of station for
Who?
domestic problem.
Who is your main counsel?
KLO Lordship, KMO Lordship. I have taken consent from other side also.
So,
In item 8, I'm appearing for the petitioner.
Mr.
Jeeta,
I have a reservation in taking up this matter also. Mr.
Jeeta Lordship.
Jeeta, learned counsel for the learned counsel appearing on behalf of the respondent. Praise for listing the matter after 3 weeks.
Thanks, Lordship.
3 weeks on the ground that the leading counsel, Mr. K. Lolen, is indisposed today. Mr. D. Pangi, learned counsel for the learned counsel in criminal petition 137 is learned is present and Mr. This okay learned counsel for criminal petition 53 of 2023 as well as T8 learned additional people are present. This after 3 weeks.
Deeply obliged.
May I beg to mention item number
Yes, yes.
7? Item number 7 and
7.
7 and 18.
7 is for what?
It's a civil dispute over a position of over ownership of Mithun.
Mithun.
Yes. Yes, sir, Lordship.
Still those Mithuns are alive.
Yes.
Have you
Yes,
not
sir.
used it for Nyokum festival? How many Mithuns?
Actually, there were only
Anyway, Mr.
L. Tikak on behalf
LP,
on behalf of
learned
the-
counsel appearing on behalf of Mr. T. Tagum, learned counsel for the appellant. List this matter after 4 weeks. On the prayer, huh? 4 weeks.
Yes.
Then-
item number 18.
18 is what?
It's a service termination matter.
Hmm.
And I'm on behalf of the
So it
pending
is in
document.
order stage, we'll see. What is there, we'll see. You be there.
Okay.
Item 18.
Bless you.
Yes. Please hurry
Yeah,
up.
Your Lordship.
Hmm.
Your Lordship, I beg to mention item number 21 to 25, Your Lordship.
21.
To 25, Your Lordship.
What
Your
is it?
Lordship, here in this case, Your Lordship, I was supposed to file reply on IA filed by the respondent.
Hmm.
Your Lordship, reply is ready.
It's in order, we'll see. Be there.
Okay,
We'll see. Be there.
much obliged.
Heard Mr. D. come to learned counsel for the petition, applicant, the petitioner. Petitioner.
Yes.
Also no. This is an application under section 439 of CRPC, 1977. Praying for release of the accused, namely Sri Tony Lolen, on bail in connection with PS case number 74 of 2023 under section 302 120 capital B 50734 IPC. Call for the case diary.
LCR,
LCR.
which are seated.
Call for the scanned copy of LCR. Mr. T. at the learned additional PP appears on behalf of the state. List after
Lordship may fix the matter on 22nd.
list on 22nd, 2022, 05, 2024.
Obliged.
My pleasure, Lordship. This is a criminal petition, my lord, the petitioners have come to amicable settlement, my lord. This is unfortunate vehicle accident where the petitioner number one's brother hit the
Okay.
RTBP vehicle.
How can you compromise this?
No, it can be, my lord, 3048,
Huh?
3048. It's an accident, my lord.
Washing of FIR.
Yes.
And Mr. Peter Portland, counsel for the petitioners. The petitioners have filed the application, this application under section 482 CRPC, 1970 have been jointly filed by, not have been, are being filed jointly by the petitioners for praying for quashment of first information report of Doimuk PS case number 78 of 2023 under section 279 304 within bracket capital A 337 of IPC. Call for the case diary.
Case
Get
diary.
Copy of the case diary.
Right.
Mr. T. Leonard, additional PP appears for state. That's all.
Yes, but 304 punishable up to 2 years only.
Hmm. This one,
Yes,
304,
4A, yes,
304A,
yes.
punishable after
Up to 2 years.
2 years.
Obliged.
List after 4 weeks,
Yes,
3 weeks,
3 weeks will sufficient. Doimuk manner.
3 weeks.
Obliged.
Your Lordship, a specific date may be given because CD has to be called for a specific.
3 acts on
Maybe on
29
Your Lordship,
29 to 29
May.
6.
29/5 this month.
Then 3 this
Then maybe on Your Lordship, 5th of June, 25,
5th of
please,
June.
5, 6,
5th of June.
5th of June.
0506 2020.
Obliged.
Deeply obliged.
Sir, what is this?
Lordship, this matter is regarding this land matter, eviction. Lordship, this matter was fixed for disposal today and on the last occasion record was called, matter was fixed before the justice spoken, but
What is
he's
this?
absent today.
What is your prayer?
My prayer is just simple prayer, Lordship, for suspension of that eviction notice.
You just cannot suspend
one
like that.
One of the prayer is for this disposal of my file pending appeal before the deputy commissioner against my occupied land.
We'll ask for the instruction. What happened?
Already instruction. has
Yes,
been-
madam, what is any instruction? What happened to his appeal?
Lordship, last occasion, the
Statutory appeal.
last occasion, Lordship, the record was called.
We'll
for-
list it on Friday. You obtained the instruction. What happened to that appeal filed by him? Whether there is an appeal or not.
Lordship, in his, if Lordship,
I have,
may kindly see the response.
Lordship, I have filed
He
that
was
one additional
given
affidavit.
eviction notice in 20 September 2021, Lordship.
Yes.
Lordship. After that, without so causing anything, Lordship, he have directly appealed to the Lordship Deputy Commissioner against this eviction order.
Where is the eviction order?
Eviction order is Lordship at the page.
So cause page 22. Annexure 5.
Yes, Lordship. November 2021, Lordship.
You have filed an appeal against this.
Yes,
On
Against
what
this-
ground?
because on that day, when this eviction notice was issued,
Does
I
the
reported
state,
before the
does the
state officer.
state officer
Yes,
doesn't have
state
the,
officer.
has the authority to issue so cause under section 54.
Yes, state officer.
Is that,
Ah.
sir?
Yes, state
He has
officer.
the authority.
Appellate authority is deputy commissioner, and state officer is the.
See, first you have to reply to the so cause.
Yes, Lordship.
Uh,
Without
Lordship,
doing that, he have directly.
When I went to when people on the day fix, they were intending to evict my land, evict from my dad. That is why
We don't know. It's a
I
court
went
of
there.
record. We'll go by the record.
yes.
You read you see
On the next day, when I went before the.
you
appear
cannot
before
file an
the-
appeal just like that. First, you have to reply to the so cause.
That is why,
Thereafter, only you have to.
that is why,
There is no final order from the
Eviction Act
estate officer, Lordship. No
2003.
final order. Lordship. Volume 8.
You want it to be disposed of,
yes,
this matter?
yes.
Yes, I'll dispose of it and dismiss it. When did you file the writ petition?
Recently, they, on 3 May.
2000?
Because
Yes.
since May submit, because it is already after eviction notice, I appeal before the deputy commissioner. Then this eviction notice is of 2021. From 2021 today, it is 2024. But there was nothing, any eviction process initiated against me. And recently, there is a team of officers that is called demolition. What is called, yes,
You read section 12.
demolition officer.
Read section 12.
That is why, Lordship, when I,
That is why this will be
Yes.
dismissed.
Lordship, that is why I appeal before the.
You cannot file an appeal against the section 4 notice. Because after section 4, on your reply or whatever, the further process is there. Section 5, section 6, section 7, section 8. Then only you can file an appeal.
That is why, Lordship,
Read section 12. It's written in English,
yes, it is written in English, Lordship.
not in
What-
Arabic.
What happened, Lordship? On the background picture, I would like to this.
Forget about background. We'll go by the records and the law,
Yes,
provisions of law.
the state officer has failed to pass order under section 5, 7, and 8. But he was insisting for this eviction. If the state officer.
You have been
pass-
evicted now.
No, I'm
We'll
still
take it
here.
up on Friday. You take instruction, madam. What happened to it? We'll dismiss on Friday.
Lordship, this
Lordship,
appeal to the, this is also for consideration for regularization, Lordship.
It's okay. Otherwise, so he cannot file an
Unauthorized
appeal.
occupation doesn't give him any right to be considered, Lordship.
No appeal. You have filed an appeal against the impure order of so-called notice under
Yes.
section 4. You cannot. Read section 12.
exactly not section 4. This is
If not section
Who is-
4, you
who
cannot
is-
file an appeal.
who is the person who is aggrieved by the action of the state officer. That is the first issue here. Who is aggrieved with the.
That
this is
first issue has to
not-
be related to the provisions under which you are claiming your right.
One thing, Lordship, one thing may be done. I may be allowed to this submit reply this so-called notice before the state officer. In the meantime, this
It's too
temporary.
it's too late in a day. You have
because
missed the bus.
their authority is suspended. The authority is initiating eviction, whereas this eviction order is of 2021.
You have been given how many days?
On the
Yes.
day itself, on the next day, then reported, I appear before this, in the 2021, I appear before this state officer. But the state officer was not sitting there on that day.
10
He was
days.
working on any other activities.
That cannot, this
That is-
sanction cannot be taken. Lordship.
And this notice was issued in 9th of November 2021.
Yes.
And
You are
his,
coming in 2024.
and Lordship, his appeal again, appeal is in,
I'm coming here because in 2024, this, without any so-called press, so-called.
Heard Mr. T. Tapak, learned counsel for the petitioner. The challenge made in this writ petition is to the so-called notice issued by the state officer, East Siang District, under Section 4 of Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Act 2003. I've mentioned the date. Dated, did I mention it? So, dated 09/11/2021. And also prayed for disposal of the appeal filed by the petitioner on 1/8/11/2021.
1811, Lordship.
18/11/2021. Purportedly against the impugned show cause notice. On the perusal of the provision of section 12 of the, you just mentioned that Eviction Act 2000, same, huh? Arunachal Pradesh Public Premise Eviction, huh? 2020. An appeal lies against the order of state officer passed under section 5 or section 5, 7, 8 or section 10 before the appellate authority. Mr. The it is noticed that the petitioner or the responding to the so-called notice and the impugned so-called notice under section 4,
Lordship, I have stated the ground.
stated to have filed an appeal
Para 6.
for regulation of the government land occupied by him. Him or her? Him.
Her.
Her. Having considered about the MS G. Ethel, an additional senior government advocate appearing on behalf of
3 and 4, Lordship.
state 3 and 4 is granted 4 weeks time to obtain instruction.
Lordship, it will this affect in case of my eviction. It will. I have constructed RCC building.
Will direct them to evict you.
Lordship, some short time may be given, Lordship. And interim order. This I have a prayer for interim.
Can you obtain by Friday?
interim hearing, Lordship.
Lordship.
I come here for
Unofficially, I have-
justice, Lord.
I'm not issuing a notice. Even it is not fit for issuance of notice also.
Yes, Lordship. Unofficially, I have asked them, Lordship, I have called
Already
them.
as per the
they have
last
said
last
they have-
court order, Lordship, that is a clear cut instruction to the government advocate to furnish the record, Lordship, today. Kindly see that this last court order.
Lordship, records so far, he have said that, is that he have filed
What
application
instruction-
in the year
instruction government
2008.
advocate has taken.
Let me complete. In the year 2008, Lordship, that is not in the record, Lordship. But then 2021 application are in
Very
receipt.
much in the casual approach.
It is here, Lordship.
Yes, yes.
It is here.
You're supposed to place the records. Why you don't have the records?
Records, Lordship, in the form of this one, they sent me in the
Then-
PDF, so I put, print it out on.
Having considered above, huh? No, no, before that. This code on 0705/2024.
I have the record
Huh?
in the form of, I have
Says
printed
that
out here, Lordship. So,
Record is there.
Original record, call for original records. Have you seen the order of 0705?
yeah, I have seen, Lordship.
You bring the original record.
Original record is. only-
0705/2024, directed the
I have sent the
Second.
order also, but then,
authority to.
Hmm.
Yeah, this court has called for the original records along with the application of petitioner relating to regularization of the occupied the land of the petitioner. Well, having considered above, the learned MS, then you write MSG at so and so and so is granted further 3 weeks time to obtain instruction.
Lordship, matter may be fixed on Monday. Otherwise, it will be infractions, Lordship. In case of eviction, Lordship. If I am given this interim protection, then it is all right, Lordship. Otherwise, it will be injustice, Lordship.
You have illegally occupied a government land.
Yes.
And illegally you have
Lordship, as per the land allotment relevant rule, Lordship,
We'll
I
see.
have the right to be, I am eligible for land, Lordship. As
Okay.
per Arunachal Pradesh land settlement rule.
See,
under
we
rule
cannot
123.
jump here and there.
Yes,
You are against the eviction order.
yes, I am against the
And
eviction
you have
order
not
because
reply to the eviction order.
I am against the eviction order because
After
Lordship,
3 weeks,
Lordship, this is
why not
within
issuing
the
notice?
office
Lords-
compound area, Lordship.
particular,
They want the office for
You
expansion.
come up with
official-
original records and file an affidavit.
Yes, Lordship.
Still case,
particular, short date may
making
be
your
fixed.
state
Lordship.
clear.
Short date may be fixed on
After
2021, Lordship.
After 2 weeks.
It-
have to
it
file
will-
an affidavit.
In case of my eviction, if interim protection is there, that is all right, Lordship. Otherwise, it will hamper the
how-
process, Lordship.
How the courts pass an interim order?
In that
on what
case,
basis?
short date maybe we can, I either dispose the matter, Lordship, on the next that let the record be, both before this court and, on
Hard-
20 or 21, Lordship.
Hard on interim, next para.
Yeah.
Considering that neither the petitioner has response to the impugned show cause notice, nor she has filed an appeal in accordance with the provisions of law. That to impugned show cause notice was issued on 9/11/2021, the prayer for interim is rejected. Yes,
Matter
after
may
2
be
weeks.
disposed of, Lordship. Fixed, Lordship.
After 2 weeks, sir, we have passed the order.
My please, Lordship. Lordship,
Yes.
this is regarding pending business. This is a covered case, madam, already. Many. This was 2013.
Heard Mr. Peter Paul, learned counsel for the petitioner. By filing this application, the petitioner aspired for a direction for payment of rupees 15,80,275.00 within bracket, you write in words, huh? Rupees 15,80,275. What is this in letter 2104?
But this is the, my lord, the bill signed by the executive engineer, final bill, my lord.
In terms of the final bill,
Yes.
is stated to have been admitted by letter dated 21/01/2024 by the which respondent number 3, the comma DPUI is page 5, huh? Rural Works Department SEPA is coming this week. Issue notice returnable by 3 weeks.
Obliged.
Mr. G. Tarak, Learned Extending Council, RWD, Rural Works Department, accepts notice on behalf of respondents. No forward notice needs to be served. However, extra copy if
Yes.
required. be
Sir,
furnished.
today is submitted, sir. Obliged.
Always.
During the course of the list after 3 weeks.
My lord,
What is this?
my lord, this is,
This is nothing. Will impose you a cost. How can you file a writ petition against a political party?
I have not exactly my particular information to the respondent number 6, who.
It's a dispute within your party. How do we know? Who has terminated you?
Respondent number 6.
From where? Is
Uh,
it a public post? Is it a public post?
the Mandal unit.
Mr. Nebo, I'm sorry.
My lord, the nature of termination.
When did you join the bar?
My lord, nature of termination.
How many years of practice you have?
My lord, as per BJP rule, they have not even served a notice.
I'm sorry. Will impose a cost. How this is maintainable, writ petition against the political party? This is a basic, sir.
My lord, what I understand is that Mr. Tattapak, who happens to be a Mandal unit, the president of Mandal unit, is abusing the power and position of his being Mandal president.
Sir,
And
don't,
without
don't
notice, but he has even violated their own rules of BJP political party, and self-stylely he terminated.
sir,
again, he-
don't compel me to say more than what I have indicated. It will be detrimental to you. When did you join the profession? This is a basic thing. You are a high court lawyer. What is Article 226?
if under Article 226, even the personal right is being violated, can approach. by the-
Against whom? Against whom?
Against particular authority who has issued
Who is the authority
the Mandal, represent Mandal
of a
unit.
political party?
Yeah,
Is it the political falls under the other authority of the state? Or instrumentality of the state? Then
no, this is of course, this is a political, but
this is too much. Sir, what is to be done? This is a height. A lawyer like Nebo filing a writ petition against a political party. Will recommend it how you have obtained the license to practice.
well, as per my understanding, if my right has been violated, I can approach before the court because the
Against whom? What is to be done? Read lies against the political party. You have a liberty. There are forums.
my lord, in that case, I'd like you to with the liberty.
But we don't expect lawyer stature of a lawyer like you to commit such a
Anyway, my lord, I'll withdraw the petition.
heard Mr. M. Nebo, learned counsel for the petition. Realizing that the relief sought for in this petition is against a political party. Which where no writ petition lies against Mr. Mr. Nebo press for withdrawal of the writ petition. List of prayers allowed. The writ petition stands dismissed on withdrawal. List of. It goes without saying that the lawyer stature of a lawyer like Nebo would at least have a basic knowledge of the writ jurisdiction. List of. That's all.
My lord,
It is
that,
not done.
that not very reflective.
Hmm?
That last line may not be reflective.
I'll think over it. At
Since
least
I'm
have some
withdraw-
basic.
My lord, particularly what I thought is that the particular respondent is individually doing in his own capacity.
You
by
don't-
abusing the power of the Mandal unit. That is why I have entered para, I have not said anything about a
Civil
political
court is
party.
there. Civil court is there.
That is why he says he has violated their own political.
Are you
party's
still
rule.
justifying? Should I add some more?
No, my lord. Delete some words, last words.
The Guwahati High Court Bar Association Eternal Permanent Bench is requested to have a periodical training on the lawyers for the interest of all. I'll see before signing, I'll think over it.
Okay, okay, my lord, please. Oblige, my lord.
In that affidavit. Yes. After some time.
Yes, sir.
What is to be done
It
in view of the settlement?
Needs to be closed here and we'll approach the court below. So we'll
That's
clear-
all, we'll just write like that. Mr. You are appearing for respondent. Mr.
KM Mahanta.
K. Mahanta, learned counsel for the appellant. I heard Mr. K. Mahanta, learned counsel for the appellant, and also heard Mr.
El Nara.
El Nar,
El Nara.
Nara,
Yes.
El Nara, learned counsel for respondents.
Yes.
Mr. K. Mahanta, learned counsel, semester. Yes. Filed an affidavit bringing on record the settlement between the parties. Outside the court. Is it outside the court or what?
Yes, yes,
Where it is?
page number 7. Page
And
7.
I have submits that the parties have settled the matter by an agreement of compromise dated 15/05/2024. Then have I have perused the affidavit wherein the compromise agreement dated 15/05/2024 is been annexed. Having considered the submission and the perusal of the compromise agreement, come on, this regular, this RFA
10 obligatory.
number 10 of 2018 is stands, is closed. That's all. Yes. And kind of decree need to be passed. No,
No, here degree needs to be closed.
the RFA accordingly disposed.
If the LCR is there, then LCR needs to be sent.
Huh?
If the LCR was false, then it needs to be sent.
The LCR is there. The LCR, the trial court record. Send back the, send down the trial court record. Is here.
Please, your lordship.
Yeah, in view of the other sense. No, no, IA, it's not IA. This is IA. This IA. This is additional activity. A joint affidavit, we'll see, this is joint affidavit, by filing a joint affidavit, which are parties and so on. Then in view of the order, this, I also this. Hmm. Send down the TCR, if any, if received. If, no, it's okay, that one is not there. It's not there, don't you delete that. Huh? Then the miscase will be disposed in view of the orders. Yes,
Well, the read petition was filed assailing the impugn transfer and posting order. Then there was an interim prayer that I should be allowed to continue as a SC RWD Pasigat Circle till 31st of March. On denial of the interim order by this honorable court, a read appeal number 5 was filed in the principal bench. There also the interim order was denied. However, against both the impugn order, a SLP was preferred before the apex court.
which is
And-
pending.
Yes, honorable apex court has interfered with, and the matter is pending. My lord.
What is to be
And
done?
it is, and my lord, the last, according to my record,
Who is working as a superintendent engineer?
the petitioner, my lord,
You.
I am still working.
So virtually it has been rendered infructuous if the apex learned, honorable apex cause is taking up the matter, what is to be done in this writ petition?
My lord.
In the, if the petitioner is true to his word, by this time this petition must be infructuous and he should get himself transferred.
Yet, go through the paragraph, first prayer.
Now they
I
are
have
taking
made a
shelter of
prayer
the
and he interfered.
Supreme Court order.
Come on, don't make these kind of arguments. This is not correct. And apex court is.
Mr.
My lord.
Titi Tara, learned counsel, what do you want? If the matter is a decision of the honorable. Supreme
Correct.
Court,
No,
what can-
your lordship, in fact, the prayer itself says he should be allowed to continue as SC.
What have you done there in the honorable apex court?
We are contesting.
You contest there?
My lord, please come to the page number 19, prayer, my lord, first. In the last hearing also, actually, in the last hearing also, honorable court also.
Sir, why don't you understand the predicament of this court?
My lord.
This is high court.
Yes,
That
yes,
is
my
it.
lord, yes, my lord. But we are not saying that Supreme Court is in session and that is going on. No doubt, my lord.
Because
But
there's
there's no,
nothing,
yes, my lord. We are not
There's
saying,
no-
we are not seeking any direction from your lordship, my lord.
then,
My lord, please come to the page 19, my lord. The prayer of the petitioner in the read petition, this read petition
see, all,
was that he
all of-
he
all,
should be,
all of us will be hauled up because of your,
should not be, my lord. They should not hold up, my lord. They should not hold up us, my lord, because it is,
it's okay. Heard Mr. Titi Tara, learned counsel.
my lord, basically prayer was up to allow him
Read
to
paragraph.
30 months, my lord.
Go there.
My brother, please read
My lord.
prayer number 1.
You are contesting there. Go
My lord,
there,
my lord.
contest there. before the honorable apex.
You don't go by the prayer.
No, no, no,
of my reading.
Because.
My lord,
see,
prayer is different, my lord. Prayer is different, my lord.
counter-
First
count-
prayer is different. my
see,
lord.
Counter affidavit, if any, be filed within 2 weeks, rejoinder affidavit be filed within 2 weeks thereafter, list of service pleadings are complete.
My lord. And till then, a petitioner,
Yes.
petitioner be allowed to continue there.
Yes.
We are not seeking any this intervention from this honorable court in that regard, my lord.
Yes.
We are only up to the point that prayer was, what was the appeal? Contention of the appeal. Contention of the appeal itself was that he should be, why this honorable court, single bench didn't interfere, my lord. That was the thing, my lord. And basic contention was, again, my lord, he should be allowed to interfere and he should be allowed to continue as SEF Pasigat up to 31st March 2024, my lord.
Yes.
That was the main contention. That was the appeal, my lord. It was not that this court should not have, quash it or not, my lord. Appeal was basically for non-interference.
Hmm.
My lord, appeal is very much with me. Copy of appeal is also very much with me, my lord.
Hmm. Yes, 31st, you are over.
No, my lord. There are two things. Kindly read my prayer number 1. Quashing and setting aside of the impugned order.
Hmm.
And alternative prayer, the second prayer was that I
It's
should
not
be allowed.
alternative, it's further.
Yes,
It's a further prayer.
further prayer. Further prayer.
My lord, but appeal was
Now-
not. It is the appeal petition, my lord.
No, we're not looking.
Just read that. Just, my lord, what had happened.
It's
is-
okay, we'll list after 4 weeks. Again, when it's subject to the orders or the decision that may be taken by the honorable affairs court. We'll list
And my-
after 4 weeks.
My brother wanted this
You are
court to
contesting
overstay
here.
the jurisdiction of the
Are you
apex court.
contesting
No,
here?
no, no, not that. No, not that. We have not
Heard
said,
Mr. Titi Tara,
we
learned
have
counsel
never
for the
said
petition.
honorable, this honorable court should.
Also
pass
heard Mr. G Tarak, learned standing counsel for the state respondents. Learned standing counsel for department, RW, Rural Works Department,
My lord, 3.
and Mr.
Respondent.
T Jamo for respondent number 3. Come on. It is noticed that the issue, the matter has been taken to Honorable Supreme Court wherein by the order dated 01/03/2024. The Honorable Supreme Court has issued the notice and directed to file counter affidavit to the parties, counter affidavit and rejoinders to the parties. It is stated at the bar, the respondents are contesting the matter before the Honorable Supreme Court. In view of the above, let this matter be listed after 4 weeks. List of
My lord, with the rider, that
the
parties
parties may
have
mention.
liberty to raise.
The
Make a
parties
mention.
parties are at liberty to mention the matter. Subject to the
Disposal.
subject to the order
Disposal of SLP
may
by
be-
the apex court.
passed by the
Correct.
Honorable Supreme Court.
Great.
We just cannot, over and above, we cannot do it.
No, actually, our prayer was not that, my lord. We have never said.
Last
that,
time,
we
last time, my
never-
lord, I was
What
not
is
there.
your prayer?
So both of
Our
them,
prayer was
they,
to close it, my lord, because it
they
is.
put my younger.
My lord, in our humble opinion, my lord, the appeal was not about maintainability of this transfer order, my lord. Appeal was for not granting interim order that we wanted to bring before you, lordship.
Okay,
Appeal was,
Oh, okay.
appeal was for.
thank you. You fight out there.
Great.
Yes.
Your Lordship, as according to the order dated 2nd August 2023, we were directed to take steps on respondent number 4 and 5 through paper publication.
Yes.
We have taken steps and we have also filed an affidavit regarding the same. And we have also furnished a copy to the learned advocate for respondent number 1 to 3.
So you have
So-
published in the newspaper?
Yes.
Okay. The Miss MS,
Respondent number 4 and
for
I'm for the petitioner
prisoner,
and
J Das,
yes, yeah.
MS
Yes, my
J
lord.
Das, learned counsel for the petitioner. Submitted.
My lord,
No, submits, referring to the, has submitted that. She has filed the affidavit with regard to the publication of, with regard to the service of notice upon respondent number 4 and 5 through paper publication. Mr. Where is the affidavit? The,
my lord,
in view of the publication of paper, service of notice upon respondent number 4 and 5 by through publication of paper in the times of the service in respect of respondent number 4 and 5 are complete.
my
Please
lord,
for
with this,
admission
we
here.
have finished taking all the steps.
Hmm?
We have finished taking all the steps
It's
to all the
okay.
respondents.
Huh.
So the leading advocate is from Guwahati. He has requested the matter to be listed for admission hearing
Yes,
on
this is the matter for
4th
admission hearing on when?
fixed date is
When?
required, 4th June.
On 04/05/2024, as spread by the Planet Council. Empathy.
Yes.
Empathy.
Empathy.
Learned counsel for the petitioner and
My lord, if I'm
14/05/2024 reflects that record has not been received. This registry to send a reminder for record. From which court?
From all Arunachal Pradesh, Gaupura and Gaupuru Welfare Association.
Record, I don't know. Whether they will maintain the record or not. Call for send reminder for record. Huh?
Your Lordship, if I may, Your Lordship, the Apex Customary Court has given a consent judgment and mutual settlement between both the parties. And this is the OP of mutual settlement and consent judgment.
You file an affidavit. The parties, in the meantime, parties may file affidavit.
Lordship, I'm taking steps on the sole respondent.
Huh? You've taken?
Yes.
It was Mr. Mr. G. Katola, Council for the it was service report for responding. List after 3 weeks.
Yes.
When did you take the step?
It is on
22/3. We'll wait for some time and then we'll see. List after 3 weeks.
Okay.
in village council.
My lord, in terms of the direction, the Honorable Court, on the last occasion, it appears that the government advocate has filed additional informations. My lord, if I take your lordship to the letter that 22/4/2023 and instruction that 6/6/2023 and the affidavit filed by the state on 3/10/2023, it is very, very clear that the collector, who is the assigned officer to undertake the process of acquisition, has categorically stated that no land acquisition records are available in the district. And not only this, my lord, in their reply to the RTI also, they have clearly stated that there is no acquisition of land. Now, the user agency, that is the Ministry of Defense, they are only saying that these were acquired as per law and my lord, which are not at all the processes to be adopted under the Land Acquisition Act. They have issued the preliminary notification under Section 4, and that also the parties were not, the persons interested, quote unquote, were not given notice, no process under Section 5, and later on they have issued a section notice under Section 6 and 7 only. That's all, my lord, as per their records. My lord, my actual submission is that they have attempted to show that the land acquisition process were followed, but it was not followed properly. And therefore, this is it cannot be said that the land acquisition procedure were followed, and there is no records of payment of compensation, my lord. Now, my lord, how the Ministry of Defense are claiming, before I come to the affidavit and the instruction and the
No,
additional
Sir,
instructions.
this speaks for orders today. They are supposed to file an affidavit. And the instruction, what instruction you have? You are supposed to file an affidavit. Why? No affidavit.
They have not, I don't think they will change their stand because they have filed an affidavit before the National Commission Procedural Tribe. There they have the facts, the measurement of the land, the land was under hire, everything, facts are not at all disputed. Only dispute is whether the acquisition was carried out as per law or not. That is only to be determined. And they cannot change their stand.
You have been given last occasion, 3 weeks time was granted. Why?
In fact, my lord,
We'll have to-
correspondence is.
What to do?
My lord,
You understand.
otherwise, my lord, what is the
You
role?
understand better than us.
My lord, otherwise, what is the role of the user agency?
Yes.
It is not. It cannot be said that user agency
Okay,
has
we'll
no
grant
role.
it-
But then,
Grant him another 3 weeks time, for that time. And then what is your instruction? What is your
For
instruction? sir?
lordship, we really don't have the records of the acquisition.
That is the instruction.
Lordship. Repeated instruction is that only. In affidavit also, we have stated the same.
on oath.
No records?
Uh,
No proceeding what is
No,
indicated?
no
Except
records at all regarding.
Section 4 and 7.
Lordship.
Initially, it was under section 4
Yes,
and then section 6.
Section 6, as per the records by the Ministry of Defense,
Hmm.
and they have
According to
directly
you,
issued the award.
We don't have the record.
You don't have any records.
Records.
Even section 4, section
No,
6,
Lordship,
nothing.
we don't have any record regarding
You
the.
file an affidavit to that.
No, that already has been filed. To that,
We have filed it, Lordship.
Where it is? Where you have said? Let us see. Respondent number 6.
Respondent number 6.
you also may come to paragraph 6. May I read, my lord?
7.
That with regards to statement made in paragraph 8 of the writ petition, the answering respondent begs to state that it is true that in the year 2002 and 2003, a joint survey was conducted by the representative of Singsung Village Council. Well, here, because there are two cases,
So there is Stafford, it should be TBC. Sing Sung also was there. The Army Defense Officer in the Civil Administration, and it was found that total area measuring such census under occupation of Army at Sing Sung area. Malad, it should be 432.47 acres under Tukten village. And again, at paragraph 7, that with regards to the
So you don't have dispute over this 277.03.
No, that is not disputed, Malad.
So this has been acquired,
This has been acquired.
and out of which 61 acres were from Rupa.
No,
You are
but
also not disputing.
this is not disputed. Only that matter is
With regard to 432.
432.
This
And-
61, 177, no dispute.
No, there is no. We have received the money also. We have stated in our writ petition also, Malad.
So
Malad,
in that case, it is more, I mean, we'll have to hear him. They will see their
you
step.
Lordship may just Malad, just you Lordship may kindly come to page 58 of my writ petition, Malad. It is a reply to my query that where it is no land acquisition act was not invoked. Perhaps some agreements are census. But page 59. Page 59. Well, this is a communication by the Defense State Officer Tejpur to the Deputy Commissioner. With reference to letter number such and such, it is intimated that as per Government of India Ministry of Defense number such and such dated 18/9/1971, an area of measuring such and such has been acquired by Defense Department. However, Paravas replied on National Commission for Scheduled Tribe SC/ST that such and such are forwarded herewith as annexures A and B for your kind perusal. Well, perusal of this affidavit is page 60, Malad, next page. Now, why I'm saying Malad, the figures land measurement, because this was worked out in 2002 and 3. This is not disputed at all.
60, page 60.
Page 60, Malad, annexure 5. Paragraph 2, Malad. The Defense Department had acquired the land measuring such census at Tenga Circle, namely Damare, Sing Sung, and Rupa Circle measuring such
Page
census.
62,
Page 60.
60.
60. Your Lordship got it.
Defense had equivalent.
Yes, down below, Malad, 672.18. This is regarding this writ petition number 186, the next item number 16. And 432.47 acres respectively as per Land Acquisition Act 1894. 432 is this item number 15, Malad. Para
Okay,
3,
we'll consider, because in view of the stand of the collector, deputy commissioner, it's
yes, Malad.
the difference, the state, the affidavit is more, is required.
Malad, it can be disposed of at this instant because
We'll hear them. Otherwise, unnecessarily it will be taken to appeal.
Because Malad, in paragraph page 61, they have cited the orders which they claim that this is the
Yeah,
equating
we'll
orders.
consider, then let them bring on record.
Then in that case, Malad, as a last chance,
Yes. Last chance. Huh? Heard Mr. T. Patel, Land Council for the petition. This can be taken up together, both the cases.
yes, Malad.
Both the cases can be taken up together.
15, 16 years.
It's the same extent.
Lordship, almost,
What almost?
Well,
Whether
same,
it should be
same.
same or it should not, it is not.
because here
Only the area and
we
land
did not seek,
description.
we did not seek additional information on 16.
This is the same.
You take information together.
Lordship, we have filed the affidavit, Lordship.
Same extent.
Same Eastern, Lordship.
And in that case also, item number 16 also, they have taken the
Same extent.
same extent, filed the affidavit.
Then same order, one order. Mr. So-and-so, Land Council Board officials. Mr. You are for one. Respond number one. No, who is for one?
Maybe he's from 1 to 4.
One, two,
I am 6, Lordship.
Mr.
1 to
M. Kato, Leonard DSJ. pressed for some time to file affidavit in opposition in the matter. Mr. So is, no, please do. Mr. Ram for respond.
Six.
You are for?
Six.
4 and 5.
I'm,
You are not filing.
no,
Mr. D. Kamdu, Learned Standing Council for Respondent, and Mr. Ram, the additional senior government advocate for respondent number 6. Mr. The affidavit filed by the respondent number 6, Mr. Deputy Commissioner, who is the collector.
And Malad,
In a district.
instruction, then instruction and today's instruction also maybe.
Reflects that. Clearly reflects that there is no records with regard to the acquisition of the land in question. Right? Mr. Having considered above, in view of the above, this court has directed the learned additional senior government director to often put an instruction. Mr. Today, Mr. Ram, learned additional senior government submits that. There is no record. On instruction submits that there is no records with regard to the land acquisition proceedings in respect of the present land. As stated in the paragraph, is in the affidavit on behalf of the respondent number 6. Mr. So-and-so, M. Kato, DSJ is granted further 3 weeks time to file affidavit.
It's the last.
4 weeks, then 4 weeks last.
It's the last.
As a-
That court maybe.
As a last chance. But there is a record that says otherwise. They are saying that in a tribunal, they are saying that this has been acquired and all. You are saying it has not been acquired. There is no record.
Malad, I would have shown you logic that initially they are relying only on the in principle
Approval.
approval. First thing. Second is the first notice under section 4.
61, you got the compensation. In
Malad?
respect of land, 61 acres.
No, the 117, that is not disputed.
No. Have you been paid the compensation
Yes.
in those
for-
years? In
Against
those
117.
Okay. 61, you have not. This is to belongs to some other.
No. Other than this 117, no compensation was paid.
But you are not disputing 61 also.
61, Malad.
Include there are two areas.
There
One
are
is
two-
177
yes.
and 160.
Malad, in 2002 and 3, when the survey was carried out, the entire land were recognized as two aspects. One is defense A1 land and another one is excess land. Excess land is the 117 acres from where the TBC has 61 and the rest was for the Singsung village.
Okay.
But a particular date may be fixed.
You are here. 4 weeks, you make a mention.
But June, say 17.
And the other thing you have to consider these are occupied by the defense army authorities.
Well, we have we have no intention to get it back also.
It's considering the strategic
National, yes.
border state
But nevertheless, Malad,
and the national
in these notices,
national interest.
it is clearly stated that it is taken on hire.
Okay.
The hiring charge also has not been paid.
Yes, madam.
May I please Lordship, Lordship service is completed. Last order was for that's the service, yes.
Yes.
Respondent number 5 and I have. to
MS L Lambe, the counsel for the petitioner. Service is complete. list for admission any.
Yes, Lordship.
After,
Yes.
you mentioned, record her name also. Correspondent. MS Arbasser, London State Council. Have you filed the affidavit?
Lordship. Oh,
Or Mr. So and so, London Council for the petition. Petitioner,
No, respond.
who is called the petitioner? Record is, was called for and it's yet to, heard Mr. Peter London Council for the petition. And also heard Mr. You record all the, record your presence. Your name, give the name, an MSP Pang for State Council. Office note dated 10/05/24 reflects that record has not been received. Registered to send reminder. Like. Any instruction?
My lord, as per the direction of this Honorable Court on the last occasion, my lord, we have my lord, carried out the joint verification. And my lord, joint verification report is yet to be filed, my lord. So therefore, my lord, may I pray that my lord, I may be given some more time to file, my lord, the joint verification.
In respect of these cases.
My lord,
Okay.
in
Heard
IE, my
Mr.
lord, direction was given.
Heard Mr.
Indeed, on behalf of
Vijay
PJ
Sekhar,
Sekhar.
Learned Council for the petition. Vijay Sekhar, Learned Senior Council. for the
Matter may be fixed on 27.
Mr. M. Kato, Learned Council for the, Learned DSGI.
For 1 to 4, my lord. Respondent number 1 to 4.
Submits that the direction by this court.
My lord, there was a direction for my lord, the verification and verification report.
In terms of the direction of this court, comma, joint verification have already been carried out. Therefore, he prays for some time to bring on record the joint verification by filing an affidavit. You are for?
my lord, I'm for respondent number 7.
All
My
of them,
lord,
you record them, huh?
my lord,
So,
today we could,
the learned DSJ is granted 3 weeks time to, 3 weeks, 3 weeks time to bring on record the,
Lordship fixed the method.
to bring on record the joint verification report as directed by this court.
my lord, I'm for respondent number
Affidavit.
7. Today we could not file a wakalatnama because the wakalatnama is in transit. So by next
It's okay,
day,
it's fine.
and my lord, we require a extra copy of petition and IA. It will be helpful. Extra copy of petition and
We have
IA.
to furnish.
Yeah, if the petitioner.
The learned counsel for the petitioner is directed to furnish the copy of writ petition as well as the connected IA to the learned counsel for respondent number 7. You furnish?
Lordship, there is an interim order that may be considered.
The entry order first earlier shall continue.
The play placement.
May I please, Your Lordship.
Yes.
My lord, we wanted to, my lord, dispose of the IA for under 389. So therefore, Lordship, I will take. Your Lordship may kindly take up the appeal petition, man. There everything is content.
You are taking up the IA.
Yes, but the Lordship, I'll just, all the documents are there in the appeal, man. I will not take much time, man. Only 5-10 minutes.
Yes.
So,
Lordship, I have a submission, Lordship, because as the Lordship, service not completed, Lordship, the Lordship, victim party actually need to be heard, Lordship.
Not required, madam.
Lordship, this is under CRPC, Lordship. The victim party has the every right to be heard, Lordship, from the trial to the Lordship to
That's
to
appeal,
revision.
madam. In
the
case of
application.
appeal, definitely it's there.
This is
For
up-
suspension of sentence, madam. If 389, my sister can show that in 389, the notice should go to the accused, the complainant, madam. That's not there. First instance, madam, this 389 should be taken up.
Yes,
Lordship, because we have to see this, the sentencing that has been done, madam. Only 3 years. In case of heinous offense, definitely the notice should go and public prosecutor should be allowed to file affidavit, madam. That's case in the heinous offenses. This is only 3 years imprisonment.
325.
Yes.
325
367 is Lordship
367,
kidnapping, Lordship.
yes.
It's a 10 years, Lordship.
I don't know. This sentencing is 3 years only, madam. Here.
367 is 3 months. No, no. Where's that sentence?
Lordship, that's why, madam, it's page 29, madam, appeal. Para 25. In present, if case officer 325 punishable up to 7 years and offense 367 punishable up to 10 years with fine and such. The convict is not eligible to consider 367 protection of offender act. However, after consideration of entire materials on record, the age of convict lenient consideration adopted while sentenced, the convict Gucci Parang is sentenced to rigorous imprisonment for 3 years and payment of fine of ₹5,000 for offense voluntary causing grievous hurt punishable under 325 IPC.
3 and 4 years.
Marat?
3 and 4 years.
Yes, 3 years. And yes, Gucci Parang is further sentenced to undergo rigorous imprisonment 4 years, payment of fine of ₹5,000, offense abducting victim in order to cause grievous hurt punishable under section 367, which is the court finds it just and will cause justice in default payment of such convict is to undergo further simple imprisonment of 3 months in addition to above. Since all the sentences are to run concurrently. That's the maximum is 4 years.
4 years.
Lordship, what if I can convince this honorable court that
No, this, you first, both of you decide whether the notice of the
Lordship 389
informant or the victim,
389 may continue.
389 can be,
Yes, but
because on the last, the court has issued a notice. Whenever the last notice,
notice was
when did you take the notice?
18/3 month.
18/3/2023.
Yes, the 24.
18/3.
Yes.
Yes, we can wait for some time, I think.
Well, Lordship,
It's better
Lordship,
to hear them.
That's why Lordship, your Lordship fixed it today, Malav. Yesterday. it was
I
taken
wanted
up.
to see, but then
Now, Lordship, kindly see the provision 389.
it's okay. She has an objection.
No, Malav, no, if I can prima facie show this honorable
See,
court.
whether notice also the 389 can be taken, application
ma'am.
can be taken up.
In sub clause 2, Malav, in that case, definitely notice has to go and public prosecutor should file affidavit. But that's the provision.
This. Lordship, this notification dated 21 December 21, Lordship. This is a High Court notification, Lordship.
What notification?
Well, this has all, that's why they have been implemented, but that's different, Malav. We have, that's why by that notification, we have implemented them.
She wants to submit that if you have implemented,
Lordship.
unless the notice is served, it is as good as not implementing. Once you have implemented, by virtue of this
No,
notification,
my lord, I'll just.
the one has to be, notice has to be served, then only.
So I'll read 389 CRPC, what it says, my lordship.
Yes.
389 says, pending any appeal by convicted person, the appellate court may reasons to be recorded by writing order that execution sentence or order appeal against be suspended. And so if he is in confinement, that he be released on bail on his personal bond. That provided, ma'am. Here it comes, provided the appellate court shall, before releasing on bail or on his own bond, a convicted person who is convicted of an offense punishable with death or imprisonment for life or imprisonment term not less than 10 years shall give an opportunity to the public prosecutor for show cause in writing against such release. This is the model. In cases where the punishment is more than 7 years. If I can,
Yes.
Lordship, if I can.
What is your ground?
If I can satisfy this honorable court, prima facie, the accused has very good case and he is likely to, my lord,
5 minutes.
succeed. Yes, my lord. Therefore, lordship has already seen.
We'll hear. We'll consider, we'll dispose of.
Your lordship has already seen the conviction
Yes.
is for maximum 4 years.
Hmm.
Lordship may kindly, first of all, the FIR law.
Hmm.
FIR is page 32, Lordship. Type copy is 33.
Hmm.
I'll skip the content, man. FIR against Gucci Laura, man. This may kindly be noted. It was against Gucci Laura.
You are?
Gucci Paran. Now, this is FIR against Gucci Laura. The identification itself is in doubt, but now lordship will see the statement of the victim, page 42, lordship, very small.
Yes.
On being examined, he stated that I am a student of class 11 at such and such school, Pampoli, Sepaon.
It's 161.
Yes, no, that's why I'm allowed. Now 161, I will read the deposition of before the court also.
Yes.
On 13/7/15, while I was playing at General Ground, Sepa, one of my brothers-in-law named Mr. Relo Veli asked me to fetch a red color personal motorcycle, which was parked in front of the district hospital, Sepa, and was handed over the bike key. Accordingly, I went to district hospital, Sepa. I found a red color person, motorbike, and inside the key, the lock opened, started bike, and came to Kids Care School for some work. While returning back towards home, two people stopped near the school and asked me about the bike. I told them, fact, but two persons beat me up and took to type 1 colony where I was again beaten up and one of my tooth was broken. Later on, my repeated request, I was taken to brother-in-law house, Niari Valley Model Village. The group had charged their motorcycle, was stolen by me. Later on, I saw the mistake. I had started and taken another personal motorcycle bearing number such and such, whereas I was supposed to take the bike, the AR0247. However, the key was, which was handed over to me, for fits the and start both motorcycles. Here, the lordship, the name of the appellant has not been taken, first of all. Now, if the lordship sees the deposition before the court, because the conviction has been based solely on his statement. Page 70, 71.
77.
70.
70.
Yes.
Hmm.
Here, for the first time, now lordship may kindly see, I'll just skip the rest he has already said. If your lordship,
Yes, read it.
that's in the middle, my lord. I remember, it will suffice, my lord. If your lordship got, I remember, one of the persons who tied me and assaulted me is Gucci Parang, my lord. I will be able to identify Gucci Parang and his companion who has assaulted me. I will be able to, my lord.
And his companion.
Yes, I was taken to his resident Taiwan colony, physically assaulted me. I have sustained injury such and such. Mother, for the first time, he takes the name of says it was Gucci Parang, and he will be able to identify Malolo. This may kindly be marked, Malo. He has not identified the appellant in the court. He says he will be able to identify. He didn't say that person standing in the dock is Gucci Parang who assaulted me.
You are
That's
Gucci
no-
Parang.
Yes.
Hmm.
So there was no identification at all, madam.
So you want that this 161 has to be realized rather than the
No,
deposition before the-
I'm not on that. But the law is, my lord, if person is already known by the witnesses or the victim, my lord, then he can identify. But if he has not identified the person during that inquiry investigation, if he identifies that person for the first time in court, my lord, that cannot be taken into consideration. Takes the name. Now, that's why this of the learned trial court, he says that another person also I will be able to identify that person. Man. He has not been convicted. Man. Otherwise, the section 34 is there. He has been given the benefit of the doubt.
I remember one of the members who told me in essentially Gucci.
Yes. I will be able to identify Gucci Parang, his companion who has assaulted me. Man. He will be able to identify. Man. In criminal proceeding, one has to be identified. Man. Lordship, I will just refer my citation this 2002 7 SCC, man. Dana Yadav was a state of Bihar, man. Page 295. 2002 7 SCC 295. I'll not read entire para 33. Here, Malab, I'm reading it. Doman Yadav, appellant 2, who was also named Nirpa's information report. This appellant, Malab, this is Dana Yadav, para 33.
Just wait.
Doman Yadav, appellant 2, was also named in the first information report. This appellant was not named by PWD3 and PW9 in their statement made before the policeman. But in court, they had named and identified him. No explanation whatsoever is forthcoming for non-disclosure of his name before the police by the witnesses. Therefore, his identification for the first time in the court by these witnesses as a rule of prudence and not rule of law should not be relied upon. This is the, that's why this Dana Yadav was acquitted by Honorable Supreme Court. In para 38, Lordship. Rest is about other accused persons, my lord. Their conviction were upheld. In case of Dana Yadav, Honorable Court, Supreme Court acquitted him. Just because he was not named before the police. The rest is about the other accused persons, appellants, my lord. Their conviction was confirmed, my lord. And para 38, my lord, F, rest is not required. It page 316. It starts from F, my lord. We are concerned with F. Page 316.
Dana Yadav,
My lord,
who is appellant number 3.
my lord, appellant number 3, my lord.
Appeal of appellant number 3 is allowed is conviction. Para 33 talks about Daman Yadav.
No. Daman Yadav, appellant 2 was also named in first information report. This appellant means Dana Yadav. This Daman Yadav is appellant number 2. Man. So if lordship sees the here in para 39, man, appellant 1, 2, 4, 6 and 7, their sentences were, my lord, upheld. In the case of this appellant Dana Yadav, the conviction was set aside. Para 39. Daman Yadav, he would appellant number 2. He was his conviction was upheld because his name was there in the affair.
So by showing this, your submission is that prima facie, the conviction and sentence is not sustainable.
Cannot sustain.
Prima facie.
Yes, ma'am. Therefore,
Because he has not identified.
He has not been identified. The prosecution.
By any statement before the police.
Yes, the prosecution
In a
ought
court,
to.
You cannot.
The prosecution ought to have fixed another date and made the.
But it's not it's not a law.
That's why for the first time.
It's not a proposition as such. On its facts only this has been.
Yes, my lord. In this is covers.
Therefore, his identification for the first time in the court by this witness as a rule of prudence and not rule of law should not be relied upon.
That's why
Supreme Court has not laid down a law.
no. That's why the prima facie Honorable Supreme Court said, madam. That's why because he has been identified for the first time before the court, man. The conviction cannot sustain, man. That's why his conviction was set aside.
You know, it's 389. It's not a matter of right. It's a relief only.
Yes. No,
It's
my
not a
lord.
matter of right. It's
No.
not a right. As such.
No.
That the conviction and your sentence should be
No,
suspended.
I'm not saying
It
that.
should be granted.
But I have to,
Only what we have to see is the court has to see is whether prima facie
yes.
the conviction or sentence is sustainable. Prima facie, we cannot have a detailed examination.
Yes, no, that's why I didn't deal the other things, my lord. That's why I'm confined to that only. So, my lord.
And who you are a student,
Yes.
still a student.
Yes. Yes.
How many accused?
There were 2 accused. Sir.
Otherwise has been
Yes, he has been
acquitted.
acquitted. Yes.
Okay.
Just only because the person has now lodged in, can you see, this FIR was lodged as against Gucci Laura, my lord. And how?
He has been acquitted.
No, the other person name is different, my lord. He has been acquitted.
He's a different person.
Yes,
The
different
name
person.
and affair is someone
Yes, my lord.
different
That's why
from all the accused.
Lordship, the prosecution should
Other
be,
than the accused.
yes, should be specific about the identity of a person, my lord. This specifically, this alleged, this is the solely based on conviction, based on his statement alone. And he has not identified, my lord, in this case. He said he will be able to identify. And that's for the first time he named as a Gucci Parang, not even as a Gucci Lora. How he has come to know that name?
Gucci Parang.
Yes.
It's very confusing. You are
I'm Gucci Parang definitely, man. But in the FIR, I was named as a Gucci Lora, man.
Gucci Lora.
Yes.
Is it not a typing mistake?
No, no, definitely it cannot be, man. Now,
Page 42 is a 161 statement. Right?
62, man.
Sorry, 42.
Yes, and the 161, man. He has not named
Anyone?
No. If he had named one, matter would have been different man.
This. Who is Ralo Valley?
He's the
Informant.
Informant, man.
Related to. FIR is page.
It's a, Malad, page 32, man.
That copy is 33.
Yes. This is Ralo Valley.
Brother-in-law.
Yes. Because he was not an eyewitness, man, so simply an informant only.
Hmm?
He was informant only, man.
Hmm. It was a petty issue.
Yes, man. The mistaken identity for bike, two bikes were parked, man. The unfortunate thing is this boy's key, man, fitted this accused person's bike and he took away the bike.
What is your age by now?
And I would be, man, huh?
Are you a student or you
Malad,
completed the study?
Malad, comfort, I mean, still in the union, Malad.
Yes.
Malad,
You just tell us what is
two,
the-
three more
is-
things, Malad.
Huh.
During the trial, the accused person was on bail, Malad. We never tried to jump the bail or there is nothing report against him, Malad, during the trial. He's cooperated with the trial. And the punishment that is 4 years, Malad.
Let us see the judgment of the trial court.
Judgment of the trial court, Lordship, see where the.
What is on what basis?
Yes, Lordship.
Is the
Malad, page 28, what would you, otherwise the rest is not a requirement. Page 28.
28?
Yes,
Of
para
the-
30.
Of the judgment?
Yes, para 30.
No. Is 28 of what? Judgment?
Yes, judgment, man. Page
No,
28.
There are 22 pages only.
Malad,
Only 22 pages.
Lordship, make yes, it has been the para 20, 30, man, page 28.
28.
Yes.
There is no page 28. It's
No, page 28 was.
it's of 22 pages. Your 28 pages, maybe.
No, Malad.
It's your page in the appeal.
Yes, page Malad, in appeal is page 28.
Yes. There are 30.
Yes.
Yes.
Prosecution alleged that accused Guchilo Parang and Bongali Lora in furtherance of their common intention have abducted the victim and physically assaulted him and caused grievous hurt. Informant and IO has specifically deposed that both accused, namely Gucci Parang and Bongali Lora, have abducted the victim and physically assaulted him. However, the victim during the examination has deposed that he knows and can identify accused Gucci Parang who has abducted him and physically assaulted him and broken one tooth. Hence, this court came into conclusion that accused Gucci Parang has abducted the victim and physically assaulted him and caused grievous hurt to him. In present case, though Bongali Lora is one of the accused, but victim has not specifically deposed as to whether Bongali Lora is one of the accused who abducted and physically assaulted the victim. Even the prosecution witness have failed to specify exact act committed by accused Bongali Lora to bring him within the definition of offense committed in furtherance of common intention as provided as section. Hence, this court held that prosecution has failed to prove the offense against Bongali Lora beyond reasonable doubt. However, prosecution has proved beyond reasonable doubt and accused Gucci Parang is person who abducted and physically assaulted the victim and committed offense under 325 and that one. So this is the only based solely on the victim's statement.
Are you saying it cannot be relied? Are you saying it cannot be relied?
No, what I'm saying, it can be relied. He has not identified. That's what I'm submitting. There was no identification.
Have you asked for it?
No, Malad, in trial, definitely.
Huh?
It is for the prosecution to Malad, identify and specify that this is the person who assaulted me. Is for the prosecution to prove beyond all reasonable doubt.
Okay, then.
Therefore, what I'm the punishment that has been given is also 4 years only. Well, and the accused persons has cooperated and abided by the bail terms and conditions during that whole trial. This started in 2015, 2024 he was convicted. So he has not jumped the bail or did anything. So he deserves bail also under 389. That's all.
Lordship, first of all, Lordship, apart from the notification, Lordship, one judgment also there, Jagdish Singh versus Ashish Mishra, Lordship. When the victim parties, Lordship, any victim party can be opportunity to be in hurt, Lordship, in the for the bail matter, for the education of the bail, Lordship. Yes, Lordship.
We have crossed that.
Lordship.
Now we have crossed that.
Lordship.
I have heard him. We have decided.
Lordship.
This court has decided
Yes,
to
Lordship.
hear both of you.
Lordship.
That
And-
part cross.
Lordship.
Don't go.
Lordship, here also, Lordship, they have challenged the regarding the FIR, Lordship. Like, after FIR, this 161, Lordship, as Lordship knows that, Lordship, 160 statement is inadmissible during trial, Lordship. And Lordship, in the deposition, Lordship, he mentioned his
See,
name.
What he's saying is,
Lordship.
you have not taken and identified not you, the prosecution, the victim in 161 statement. Only you have said that you will identify
No, sir.
the accused in the before the court.
No, sir.
In that case, if he has not identified and no TIP, nothing has been held, how can this can be relied? Therefore, prima facie, the conviction is not sustainable.
No.
Therefore, the sentence should be, suspended and it should be released on bail. That is his submission.
No, sir.
You
Lordship,
reply to that.
Lordship, during the whole proceeding, they have never raised this issue, Lordship, before the trial court, Lordship.
No,
They-
it's not a question of raising before the trial.
Lordship,
We are considering it for 389 application.
Lordship, and
You know, this 389 application
Lordship,
is not the appellant doesn't have a right as a matter of right. He cannot,
Lordship.
but it is a relief provided under the law. So what the court has to see, well, considering the application under 389, whether there is a prima facie
Lordship,
chance of I mean, by the appellate court, finding the conviction and sentence unsustainable.
Lordship, this prima facie that Lordship, in the Lordship paragraph 24 of the judgment Lordship, this order copy Lordship, here
Why-
Lordship, the
Why you
present.
should go for the judgment?
No, Lordship, here
You saw,
Lordship,
you saw us from the deposition.
Lordship, here Lordship,
What you have to.
yes, Lordship,
what you
deposition
have
of
to
the
argue is,
Lordship.
by showing from the deposition and all that, this learned trial court has convicted, rightly convicted. There is no manner of doubt that it may not be sustained.
Lordship, here Lordship,
Then only we reject this, or else we will allow.
Lordship, here Lordship, the injury of the injury Lordship is testified by the doctor Lordship. He's corroborated with the Lordship other witnesses Lordship.
You saw us whether this Gurung, that who?
Gucci Parang.
Gucci.
Yes.
Gucci Parang has inflicted the injury. We are not disputing. He might have, the victim might have sustained injury. Who has inflicted it? Can you show that?
Lordship, this PW2 Lordship, which is Jacob Lordship, in his
Page-
deposition Lordship, page
page-
70 Lordship.
70.
Yes, Lordship.
Yes.
Lordship, on 13/7/2025, 2015, the incident took place. I had one red color 180cc Pulsar bike. On the date of incident, I parked my bike near Medical Colony. When I came to take my bike, I have seen there were two bikes of similar color and model was parked together. By mistake, I put the ignition key of my bike on the wrong bike, thinking the same to be mine. Coincidentally, said bike also started by the key of my bike. I ride the bike for about 100 kilometers, but then I was stopped by the bike, the owner of the said bike, and they have apprehended and tied me with the ropes, alleging that I am the thief. I remember one person who tied me, assaulted me is Gucci Parang. Here, Lordship, your name is reflected, Lordship. I will be able to identify Gucci Parang and his companion who has assaulted me. I was taken to his residence at the Type 1 colony and physically assaulted me. I sustained injury in my face and one of my teeth was broken. And as I was injured, I was taken to hospital and I was medically examined and treated. One Relo Valley has submitted FIR before SEPA PS regarding the incident. This is the Lordship victim statement, Lordship, which is been deposited before the session, Judge Lordship. So Lordship here, name is Lordship clearly, Lordship here.
That is what he said. You have no, the
And Lordship,
victim has
more-
not taken his name under once before the police. You just have taken the name without any identification and saying that I'll be able to identify. Without this, there's no identification. Therefore, that cannot be accepted as per the observation of the Supreme Court. That is what he's submitting.
Lordship, here, Lordship, I remember one the person who
He
attacked
has
me. was
said
Lordship.
that who
Lordship,
tried
yes.
me and assaulted me is
Lordship.
Gucci Parang. I'll be able to identify.
Lordship, I remember,
Where
Lordship,
is
before.
where is the identification?
Lordship, here, Lordship, this is the Lordship, flowing, or this, Lordship, flow of the sentence, Lordship. I remember one of the person who tied me, assaulted me, is Gucci Parang. Then I will be able to identify, Lordship. Here, Lordship, he already remembered that he's the one, Lordship, and he can be identified. That means, Lordship, when the deposit,
Has he been identified?
Lordship, if Lordship cross Lordship, listen, there is no cross Lordship. If the cross is taken place, then he may be identified Lordship. The cross is declined Lordship by the defense counsel. It was after defense counsel, at that time he should have crossed the this defense Lordship, PW2 Lordship. It was declined by the cross Lordship by the defense. And it was the opportunity given to the defense Lordship for the cross Lordship. But it was not done, Lordship.
Burden is reversed.
Lordship.
Who has to prove?
Lordship, the Lordship, this PW2 Lordship, he made the deposition before the Honorable Court. But at that time, this opportunity is given to the defense counsel to cross this lordship statement, deposition.
Except for section 29 and 30 and evidence act, a few things, it's not as, there cannot be a concept of reverse burden.
Lordship, whatever, lordship, but in this record,
You have
lordship,
to
the cross was
see-
declined.
You
Lordship.
said, I'll identify. I mean.
Then identify, if he's produced before, it is produced before him in the direct lordship, what happened in the trial court, they have produced lordship to identify the lordship accused.
Where did he show
This
us?
by lordship, this cross been declined by the defense lordship.
What decline?
Lordship, while riding the bike, I have not seen the number plate drafted by me as elected. Here, lordship, the defense counsel has not objected,
Not a
lordship, I have
question
not
of-
raised,
It's not a question of decline. It's a question of not demolishing. the
lordship, that's why lordship. He had missed his opportunity to question this lordship, this line lordship, where you will identify it is the accused lordship. It should be done lordship at that point of time lordship. Moreover, the lordship, doctor deposition is or clearly stated this injury was there
No, we're not on injury.
lordship.
Then
If the identification lordship is issued there lordship, that is I have submission lordship. He's wanted to identify the accused lordship, but he has not been the
what
opportunity.
is
to
the
do it.
procedure for identification?
Lordship, they have to, in the trial lordship, they have produced before the court for the identified lordship. And lordship, at that point of time, lordship, he had the opportunity to identify the accused.
Who has
lordship.
to do that?
Lordship, the cross lordship.
Is it the defense?
Lordship, at that time, lordship, defense asked the accused lordship whether this is the person who has lordship, the victim person, that he is the accused or
You are
not.
trying to argue that.
Otherwise, lordship, the
defense-
PP is the one lordship
It
who.
is not the prosecution and it is the defense who has the reverse burden to prove.
Lordship.
Are you submitting that?
No, lordship, here there's a deposition lordship, which the lordship.
No, I'm
complaint party.
asking whether, who has to prove, who has to identify how it is to be proved?
Lordship, it is the lordship during the
You
procedure.
said defense.
Lordship, this
defense
defense has
cannot
the,
prove the
not
case of
lordship,
the
they have can cross the lordship. They have the right to cross the lordship, prosecution witness lordship at the time of deposition.
Yes,
This much is my submission.
anything else?
lordship.
No.
No.
Therefore, there is no prima facie case that the conviction may not be sustained,
Lordship, it's up to the.
according to you.
No,
No,
lordship,
no, I'm asking you, what is your submission?
no, my submission that
I'll have
was.
to record it, no.
Lordship, here lordship, the deposition of the PW2, it lordship, it clearly stated that he had seen the Gucci Parang who is assaulted him. As per his deposition, the Gucci Parang is the prime accused lordship who has made injury to him.
He-
personally.
Gucci Parang was the one of the persons who have assaulted
Lordship,
him.
lordship. As per
And
his
he will
deposition.
identify him. He can identify, he will
He
identify.
can, he's able to, he lordship, as per the statement, I will be able to identify, and his companion who has assaulted me.
Hmm?
Before this statement, lordship, I remember one of the person who tied me, assaulted me in Gucci
I'll
Parang.
be able to.
I will be able to, if the opportunity is given, lordship, that is the meaning thereby.
Okay, so if the opportunities are not given, you have to prove.
Lordship, as per my understanding, this sentence is like that, lordship. If the opportunity is to be given, then I will be able to, lordship.
Okay, that's all.
Yes.
Heard Mr. Peter, learned counsel for the petitioner. Yeah, learned counsel, brother. This is applicant. What do we call it?
Yes, ma'am.
Where's the IA?
Applicant is the wife, your brother, ma'am.
Hmm?
Brother.
And also had MS El Hage. For the Learned Elhage, Elhage, learned additional PP for the state. This is an application under section 389 CRPC. 1973. Praying for suspension of the sentence dated 21/02/2024. Passed by the learned session judge.
Yes, sir.
Kama, Bomdila, West Caming district, or West Caming. Under section 325/367 IPC. Whereby the accused appellant has been convicted and sentenced to 3 years rigorous imprisonment with a fine of rupees 5,000 and rigorous imprisonment for 4 years with a fine of rupees 5,000. Under section 325 and S367 IPC. And for release of the appellant accused on bail pending appeal, pending the criminal appeal, connected criminal appeal. The name of the accused is named Gucci Para. Huh? That sentence and convicted and sentenced to so and so, then you write all those. You see that sentence, huh? In a default of payment of fines, huh? The convict is to undergo so and so. You just mentioned it, huh? For the simple imprisonment 3 months in addition so and so. You just mentioned that in default. The accused, how many accused were there? Next para.
Two accused.
Two.
Yes.
The accused appellant Guru, where did Gucci Paru, yellow white. One, what is the name of that?
Bongali Lora.
Bongali Lorang.
Lora, Lorah. Bongal,
Lora.
Bonga.
Bongali Lora, Lorah. Were put on trial in connection with SEPA PS case number 76 of 2015 under section 325 public 367 34 also.
Yes.
30, under 34 IPC. How many witnesses were there? PWs.
PW's Malot.
Next para on up to during in the course of trial, you just give the number of
Yes.
PWs. Any defense witness?
No. Yeah, the defense witness was there.
Huh?
Yes. Yes, I'll just check, my lord.
So and so, presume you will examine. And so DWs. Huh?
There are 6 PW lordship
Ah,
and
6 PWs.
1 DW lordship, one on.
And 1 DWs were examined before the court. Next para. Conclusion. On the conclusion we tried. And no, the learned so and so, huh? Session judge. Bomdila session judge come. Was coming on consideration of the evidence and the materials convicted the accused so and so as mentioned above, and having no found any evidence against the other co-accused, namely Bengali Laura was acquitted. The present application has been filed for suspension of sentence by one. Who is the applicant?
The brother, my lord.
Namely
Atam Paran.
Atom Parak, who is the brother of the accused, Gucci Parak. Mr. Peter, contemplated applicant, while referring to the statement recorded under 161 CRPC and the position before the court by the victim
Yes.
submits that the victim has not mentioned the name of the accused, and then accused opponent in his deposition, in his statement recorded under 160 of CRPC. It is only before the court the victim had deposed that he remembered one of the persons who tied him and assaulted him is the accused appellant, and he will be able to identify the accused appellant and his companion who had assaulted him. That effort, the accused appellant has not been named in the FIR, and there is no identification by the victim in accordance with the law. He further submits that since the victim has not explained or non-disclosure of the name of the accused appellant before the police. His identification for the first time, his mentioning of the name of the accused appellant for the first time in the court by the victim. Victim is PW number 2. Is just a victim PW2, huh? Same cannot be relied upon. Therefore, Mr. Peter Portland consensus is that on this ground alone, the conviction and sentence privacy cannot be sustained, is not sustainable. He has placed reliance on the judgment of the Honorable Supreme Court to support his submission in the case of Dana Yadav versus State of Bihar, reported in 2002, 7 SCC 295. Just we'll see the para, you mentioned the para, just within bracket para 33 and 39, 38, 39, we'll see. You just mark it for consideration. Therefore, and as such, the president, the accused appellant, namely Buchipara, and the sentence handed over by the London Session Judge, Bomdila, was coming against the accused appellant, be suspended, and he may be released on bail. Please, sir. You have you said you have not jumped up or something like that. Any submission?
Yes,
on
no,
that?
that's what all along.
All along
during the trial.
trial. You add one more line before that, before conclusion. Mr. Tapu further submits that the accused appellant all along,
Yes,
during the trial, has not violated or what?
yes.
Any conditions imposed by the court while on bail.
Yes.
Please, sir. Then what is your submission? On the other hand, MS L. Hagel and Edison PP submits that since the PW2 victim
Okay.
has
Wait, I didn't-
clearly mentioned the name of the accused appellant
In the deposition.
in his deposition before the court. The and he has sustained an injury which is
Corroborated
supported by the evidence of doctor.
Doctor. This PW lordship.
The appeal would not be succeed. List of though the she submits that though the PW2
Lordship. PW2
has
is
had deposed that he will be able to identify the accused appellant, and there was no identification, the defense has miserably failed to demolish the deposition in the examination in chief. Therefore, the deposition has to be, the examiner chief has to be a deposition by the victim has to be accepted as truthful and credible. Mr.
Lordship, and more about this, if his evidence affirmed corroborated by the informant, which is PW3, and PW2, which is the victim, as well as the Lordship, PW4 is IO of this case, Lordship.
She further submits that the evidence of PW2 is duly corroborated by the evidence, by the statement of deposition of
One,
PWD,
one,
PW
one,
1,
three, PW1, 3, and 4 also.
1, 3, and 4.
Yes. 3 is the informant and 4 is the IO of the investigation.
1 is, who is the 1?
1 is the doctor, Lordship.
1, 3, and 9, 4.
4.
4. Next page. Consider the. I have considered the submission of learned counsel for the parties and also perused the records. Where is the record? Record. Record records. It is no longer, it is needless to observe that while considering the application under section 389 CRPC, the court is required to find out whether there is a prima facie case that the judgment and order of conviction and sentence is unsustainable. Listen. The application under the application for sentence and bail under the said provision is a relief and not a matter of right. At the same time, at the stage of consideration of the application, no meticulous examination of the evidence is required. Next page. On the perusal of the on bare perusal of the records, come on. It is seen that the name of the accused appellant has not been named in the FIR. And his name has not been mentioned in the statement under section 161 CRPC before the police. It is only before the court the PW2 has mentioned the name of the accused appellant, wherein he had deposed that he will be able to identify the accused appellant. Mr. Thereafter, there is no identification of the accused appellant as required under the provisions of law. Mr. The reliance of such deposition without there being adequate corroboration as well as without following the requirement of law would may be fatal to the case of the prosecution. Next point, having considered the above, this court is of the prime facie view that the conviction and the sentence, a conviction and a sentence by judgment order so and so may be unsustainable. Mr. Next para. It is stated at the bar that the it is submitted by the learned counsel for the applicant that the petitioner is a student of 27 years. And he has all along during the trial, all along during the investigation, during the proceedings, has not violated any conditions of the terms, any terms and conditions imposed by the court while on bail. Please. Next paragraph. Considering about the in view of the above, I'm of the view that the sentence handed over to the accused, namely Gucciparang, be suspended accordingly. The sentence so and so, dated so and so, by judgment and order dated so and so, is hereby suspended. Consequently,
So I think the bail bond lordship, they have to, before the session, what lordship, the
yes. One is personal bond or what?
Personal bond, because the bail is already, will be valid 6 months after the conviction, till 6 months. Already which he has executed.
So
that's there in judgment also.
Consequently, the accused appellant, namely so and so, shall be released on bail on his personal bond.
Personal bond.
It is satisfaction. No satisfaction.
Session court law.
Satisfaction is not required, man. In 389, it's personal bond.
A personal bond.
No, say other cases,
no satisfaction required.
No, but because bail already granted the satisfaction of the session court.
The
deeply of that.
I'll find out. The IA, this IA so and so is allowed in.
No, the main case may be listed after 2 weeks.
Next main case, list in main case, heard so and so, list this matter after.
3 weeks.
I'll be ready anytime.
Paper book is ready.
No, sir, paper book has not been called for lordship. Elsa should be called for lordship. Elsa may be called for lordship.
No, paper book is required or not?
Is it prepared? It will be easier, Malak.
No, sir.
No, it will be there. In the main, records have been received. Record is received from this and so. That is no, don't write it. Heard so and so and so, Trial court record is received. Registry to prepare the paperwork. Let the matter be listed after preparation of the paper.
Yes, ma'am. Obliged.
Obliged, Miss.
In this matter, madam, we are filing reply. We have filed reply to the IA, ma'am.
Yes.
Today we are filing.
Reply to IA.
Yes.
What is IA?
IA, they wanted the interim order to be vacated, ma'am.
Vacated, my lord.
Okay.
My lord, in this, by the order dated 23/8/2021, my lord,
Yes.
the construction of the road, highway, my lord, in the Bandarua area has been stayed, my lord. My lord, the petitioner's claim in the writ petition was that, my lord, without,
We'll take it up the day after tomorrow. We'll vacate the order. Why no construction should be stopped?
my lord, yes, ma'am, but my lord, we have partially now
construct-
constructed, my
They have
lord.
already constructed, man.
Huh?
We have
Because
already
contempt is
constructed.
there, that's why they want the order to be vacated.
They have
But,
constructed.
Yes.
We'll examine the day after tomorrow, since they have filed the affidavit today. Objection.
my lord,
Obliged.
Day after tomorrow.
Yes.
I'm of the firm view that the stay will be vacated.
No, stay, madam, they have already violated it, madam. We are in
fact-
contempt.
in fact, my
that's why
lord,
they-
Contempt we are not now at present. We are on the stay of the, vacating the stay order.
Now, madam, the stay was there because they might remove the structures and all that, madam. That's why. There won't be any evidence, madam, after they construct.
no, my lord,
That was the
for that
situation.
matter, my lord, I have annexed the photograph also, my lord. His property is still intact, my
We'll
lord.
say that the no obstruction shall be caused for construction of highway. We'll say.
Because, my lord, his claim is that, my lord, he is,
Now, he has
And-
already carried out, madam, eviction, madam.
my lord, his land
You have,
falls.
you have
No.
carried out the eviction.
No, there is no question of eviction, my lord. His property, my lord, does not fall within the right of way, my lord.
Okay. If it doesn't fall,
Yes, my lord. I in fact say, my lord, the petitioner has, my lord,
Day after
misrepresented
tomorrow, we'll
before
argue,
the
madam.
but this court is
Madam,
take it that the stay will be vacated. I mean, not even if it's not vacated technically, but the construction shall not be allowed to obstruct.
Yes, my lord.
It
If
should
he-
allow to go.
Yes, my lord. If he is entitled for any compensation, to that extent, my lord, deputy commissioner will deal with that, my lord.
Hmm.
no,
Okay,
then,
we'll take it up day after tomorrow.
My lord.
then, yes, sir.
21 to 25.
Yes.
Mr. Swenson, huh? Peter Popor. No, Mr. Arseki, London Council, London Standing Highway
Applicant.
for applicant, and Mr. Peter Popor, writ petitioners. Mr. D. Kamduk for,
In the writ petition, my lord, I am
Land management.
London Standing Council appearing for Land Management Department, in writ petitions. List the matter on 17/05/2024. Record her. GAT for GAT London Edition Senior Government Advocate for Deputy Commissioners. Yes. Six. Yes.
I is for corrections of the address of the respondent number 2 only, Lordship. Corrections of address of the respondent number 2, Lordship.
Why it is required?
Lordship.
Any objection? No.
No.
I heard Mr. Estafin Learned Council for the applicant.
Yes, sir.
Learned Standing Council,
For at least.
Arunachal Pradesh Staff Selection Board
No.
for applicant. And MS,
And on behalf of Titagum,
whatever your name,
Em ngùng nhất.
And so. By filing this application, the oh. Applicant has read for correction of the address of
Respondent number 2.
respondent number 2
In
the
paragraph 3,
connected review petition 9 of 2022. Listen. Where is the correction to be done?
para 3, my application was. In para 3, last paragraph, Lordship, the proposed new address is
The proposed the address to be corrected is as follows, huh? This last three paras. Sri Nirbhay Singh, son of so-and-so, Krishna so-and-so, Deputy Commissioner so-and-so. Huh? Last three para, huh? Sri Nirbhay Singh, son of so-and-so, in page 4, para 3. Huh? The learned counsel so-and-so has no objection. Accordingly, the application, the present application is allowed and disposed of.
registry may be
By
that.
permitting the correction of the address of the respondent number 2 as mentioned here in above.
Yes.
As noted here in above. Registry to do it or you have to do?
Lordship, registry may be directed to allow me to correct by hand, Lordship.
No, that you will have to, CIS doesn't support. You will have to file an amended cost title. You just file a cost title.
Lordship, no issue.
The applicant, the learned counsel will applicant to file amended cost title.
Lordship, no issue.
Thereafter, registry to take a call.
Lordship.
Registry to take steps accordingly. You file it and they'll wait, whatever.
Most of it.
Yes.
May I please, Your Lordship?
Yes.
This IA in item number 27
Hmm.
has been filed to strike off parties, Lordship.
Hmm.
The petitioner number 1 and 64
Hmm.
in the connected WPC number 171 do not want to
Respond number?
petitioner
Petition number
1 and 64.
1, 2,
No, not 1 to 60, 1 and 64
1 and 64.
only.
Ah.
In WPC 171, that is the connected WPC, they are no longer, they don't want to pursue the case anymore. So therefore, the names, this IA is for striking off the names, Lordship.
In WPC 171?
Yes.
Or not in other?
Yes, not in others, Lordship. Others are just connected, so therefore it's been listed.
Yes, any objection?
Strike out.
No objection. Okay. Heard me, MS. Endang in London Council for the applicant. By filing this application, the applicant has sought for, has prayed for striking off the applicant number 1 and 2.
No, 1 and 64.
1 and 64.
1 and 64.
Yes.
1 and 64. As writ petitioners.
Yes.
In the in connected WPC 171 of 2024.
1 and 64, striking out 1 and 64, strike out by IA. I'm not affidavit consulting it.
MSN Dangan Learned Council submits that the applicants who has been Who are the writ petitioners? Writ petitioners, number 1 and 64 is no longer interested to pursue the matter as a writ petitioners in the above connected writ petition. Accordingly, see, praise for strength of the above named petitioners from the said writ petition. Mr. J. Tarak, learned standing counsel for RWD. Yes. Standing counsel, and Mr. T.T. Tarak.
No, my lord, I am not.
It's not been
in fact,
implemented.
In the next IA, another IA, I have filed for the
Okay,
implement.
has no objection. Having considered above, the application is allowed, permitting the striking of the name of the petition number 1 and 2 in the connected writ petition 172.
1 and 64.
1 and 64 in connected 170. System. The name of the petition number 1 and 64 are a strike off from the area of parties.
Oblige.
The IA states allowed in this project. Yes. This is IA and all this is together, list together. It is listed together. 28, 29, 30. Sorry. 27, 28, 29 together. Then in that case, you file, no, I forgot. You file a amended course title.
Oh, oblige.
Amended course title. The learned counsel for the applicant to a petition to file an amended course title. Thereafter, the registry to take steps
Oblige.
accordingly. Then all these cases will be listed again.
It is
Main cases.
It is
on 17th.
in item number 29, they have filed an IA for implement. That was to be heard on the 17th. Order is already there to be heard on the 17th.
17.
Yes.
Why not today?
Lordship, it was to be listed on 17. This was listed today only because of
But
my
the
IA.
case in nutshell is that the Vibrant Blaze program.
Anyways,
Yeah.
I have taken time to file objections to that.
Correct.
Then,
So Lordship,
then we'll on 17.
yes,
I have no
You want to
issues.
file an objection?
yes,
In your
item 29,
okay, IA is for
Implement.
implement. They have filed an application for implement
okay.
earlier, and the date was already fixed for hearing on 17.
So we'll take it up on 17.
Yes.
So we don't have to pass any order today.
No, Lordship,
No.
anyways, it is fixed on 17. Today is listed only for my item
So
27.
this
Lordship.
order will be listed together again.
Yes,
Together again on 17th. Well, a simple thing actually, the Vibrant Blaze program,
let's argue
following
on
the PMGSY scheme. So then tender process was there already.
Don't make her wise.
No, just I'm making her apprised so that our petition
More
is not
wise.
listed in them.
Already she's wise. Don't make her more wise.
Let's not waste anyone's time
wiser.
today.
More wiser.
Making her more wiser.
Oblige.
List is on 17th.
If there's already an order, then
Order
it will
for
be
this.
listed on
Yes.
17.
Yes. Sorry, Lordship, in the main case, they were interim orders, Lordship. If
Interim order person. Main. This is what. 30, where is 30? All 30. What is 30? 30. The last. 31, yes.
But together we have some difficulty today. It will take a long time. It may not complete today. And my brother Pangin is going to Guwahati for admission of his daughter. then I have some difficulty. We had a
Well,
vote.
that's no problem. It's, these are all,
On
of course,
Tuesday,
it's
my lord.
2016
Yes.
matter. If these are private, cases, private issues.
Tuesday.
Private, thing, then, if the parties agree, I have no issue.
Difficulties, I have to go out
But
tomorrow.
problem
If it
is,
is not
the,
completed, then
what
it's-
the court, faces,
I
the
understand.
problem is.
That's why, just we are apprising in
On
advance.
litigants.
Yes.
If they are litigants and all. these
Yes,
are-
sir, I have been after this case for a long time to have it completed. I got some personal difficulty now.
But
also.
I don't find, long argument is required in this matter.
Yes, no, still. Because I have to lead evidence. after
Anyway.
the-
On the joint prayer of learned council for the parties, list this matter after,
My lord, on Tuesday.
Tuesday.
on second, 22,
Just a moment, my lord. It is
21,
21, my lord.
21/05/2022. 24.
Interim order to continue.
2016 is still interim order is there.
Yes. My lord, in fact, it is 1991 matter. I have been
Okay.
after this trying to have it completed, but something has arisen and it is something. Now I myself find myself in difficulty.
Okay.
The stars are not matching well
Hmm.
in this case.
And I also pray for some indulgence, my lord. Item 33.
Yes.
After having the conversation with Mr. Tado yesterday, I was thinking that they will take the adjournment, but they have not. My lord, this may also be taken up after 2 weeks, my lord. I have some.
On the prayer of Mr. Deepak in learned council for the appellant, list this matter. After 3 weeks,
Yes.
where you tell the PP,
Yes, Mr. Ratna is here, I told you.
you inform the PP, huh?
Yes. I would have prepared this, but.
Your lordship,
My learned friend has prepared
I
it
did
now,
that
because of
this
the
way.
experience also.
I have prepared now only, I have now prepared, your lordship.
The difficulty is,
I am
Mr.
absolutely,
Tado told me yesterday that I will not be coming, so I will not be able to do that.
in fact, your
I
lordship,
have already passed the order.
even this order,
Mr. T at the learned initial PP. That then, you just, reasonable. The opposite prayer. No, has a. What do you say? You are ready, it should be heard.
yes, your lordship.
Huh?
Today I am absolutely ready, your lordship.
Submits that he is ready for hearing in this matter. Mr. Herbert. No, that's all. The the praise for adjournment of the matter on personal difficulty. Then you write his submission, he is ready to argue the matter today. However, considering the difficulty expressed by the learned counsel to the appellate, let this matter be listed after 3 weeks.
I have some difficulty in that experience.
Mr. T at the, will not record it.
Yes, your lordship.
I'm giving you more chance to prepare more.
Otherwise, your lordship,
Because of Mr. Tado, now it appears that I am taking time.
otherwise also this matter was endorsed to him only, your lordship. Anyways,
Obliged, man.
deeply obliged.
Who is there in the PP?
Appellant
Will
is-
agree if you say that you are also ready in this matter.
Yes, your lordship, since
You
we
are
are
ready?
absent today,
You are ready.
we are ready, your lordship.
Now appears on behalf of the appellant on call. Mr. Please stop. Although Mr. T at the learned additional PP is present and ready to argue the matter, due to absence of the learned counsel for the appellant, let this matter be listed after 4 weeks.
2 weeks, 4 weeks.
weeks.
4 weeks,
4
after
weeks.
4 weeks, yes, your lordship.
When 2019, let us make it 2 weeks.
Okay, your lordship, no issue. Deeply obliged.
May, Your Lordship. Yes, sir. Your Lordship, as per the last order, Your Lordship, two substantial question was framed by Your Lordship. The number one was whether the title suit filed by the plaintiff appellant is barred by the law of limitation, estoppel, acquiescence, or waiver, Your Lordship. In this regard, Your Lordship, the learned court below has erroneously rejected and dismissed the title suit, my title suit number 2016, Your Lordship. Thereafter, the learned ADJ Basar affirmed it. There has been an erroneous application of judicial mind, Your Lordship. In this regard, may I take Your Lordship to the agreement copy? It's in page number 30. 30. Yes, 30, and type copy is page number 31. Your Lordship, may I read, Your Lordship? Page 30 is the undertaking. Actually, this is not an agreement. This is an undertaking, Your Lordship. Type copy is in page number 31. I, Sri Yorkov Gade, owner of many acres of costly land, do hereby agree to donate the land with horticulture garden to the government at free of cost, provided I am given the following facilities, Your Lordship. Here, a shop license with plot of land for shopping purpose may be immediately sanctioned. In future, any wanted facilities be given to me, for I have donated many acres of costly purchased land with a horticulture garden. This undertaking was executed in the year 1977. Thereafter, Your Lordship, the learned trial court has said that since this agreement was entered in the undertaking was entered in the year 1977, 38 years have passed by. So therefore, I am not entitled to come for title suit. In this regard, Your Lordship, while hearing the title suit, the respondent number 3, respondent number 4, that is the Executive Engineering PWD Department, who is occupying that land, has filed a deposition at the CGM court, which is in page number 70, Your Honor, page number 70. Yes. Page number 70, may I read, Your Lordship? Type copy is in page number 71, annexure 11A. Why you are not saying, is it CGM or civil judge? Chief Judicial Magistrate, civil judge. Yes, senior civil judge. Yes, Your Honor. Here, they have filed a deposition addressing Your Lordship. I'll read to the relevant portion, that is serial number 2. As per serial number 2 of the donation letter dated 0703-1977, Sri Yorkov Gade has been awarded contract work amounting to rupees 3 lakhs such and such as and when works were carried out within the donated land, copy of work order and clause such and such. Your Lordship, this undertaking, which is in annexion number 3, yes, the respondent has fulfilled the condition of that undertaking, Your since that was a continuing undertaking, Your Lordship. They have fulfilled the condition number 2 in the year 2015 by awarding me a contract work. And thereafter, since condition number 1 is of administrative nature, thereafter, I approached respondent number 3, that is EAC Tribune. Earlier, it was circle officer. I approached Tribune since the shop license and this plot for sanctioning of land, etc., land allotment is to be done by the administrative officer. After getting outright rejection, Your Lordship, from respondent number 3, then I send a legal notice. Course of action arise from that moment. The moment they denied that the undertaking which I have entered with them, the course of action will start from this moment, Your Lordship. The limitation period will start from this moment, Your Lordship. Then I send a legal notice in the year 2015. Then without, due to no response, then I sent a subsequent legal notice in the year 2016. Thereafter, action arises when the moment you send a legal notice. Yes, after I send a legal notice and after getting no reply, 2016, Your Lordship, then I filed the title suit.
The cause of,
No, according to you, the cause of action arises, had arisen the moment you send a legal notice.
no, your lordship, in here, the moment there is a breach of conditions by them, your lordship. Earlier, they were agreeing to give me the land and shop license. They were agreeing to that. Verbally, they were agreeing.
Yes.
And also, in fulfillment of the undertaking serial number 2, they have given me work order in the year 2015. So there was no point of me for going to litigation or for going to any appropriate forum, since there was.
But does it say that in case if these conditions are not fulfilled, you will be entitled to get it back?
No, actually, your lordship, this is an undertaking. It's a
Yes.
kind, this is an undertaking. Your lordship, I had challenged that my land was not, I had filed the title suit because my land was not acquired under the Land Acquisition Act. There was no norms. Basing on this undertaking only, they are occupying my land. Illegally, they are occupying my land, your lordship. Only question here is whether I will be barred by the law of limitation, your lordship. As per schedules,
Resume 2, we'll see.
like, that your lordship, after the serving of the legal notice, only the bar, the limitation period will start, your lordship. As per schedule 1, as per the schedules of limitation act, your lordship, part serial number 66, part 5, suits relating to immovable property. 66, for possession of immovable property when the plaintiff has become entitled to possession by reason of any forfeiture or breach of condition. The period of limitation will be 12 years. When the forfeiture is incurred or condition is broken, your lordship. Here in this case, your lordship, undertaking was
Limitation.
limitation. Your lordship, though the agreement was entered, this is not an agreement, your lordship itself. It's an undertaking. Was entered in the year 1977. It was continuing, and in the 2015 they had fulfilled serial number 2. But in the year 2015,
Which one?
it's page 25, page 24, schedule, part 5. Page 25. Schedules, part 5, suits relating to immovable property. Then in my case, serial number 66 will apply for possession of
66.
For possession of immovable property when the plaintiff has become entitled to possession by reason of any forfeiture or breach of condition, 12 years. When the condition is broken, your lordship. Herein, your lordship, the learned civil judge has, there was no appeal, it was ex parte. It was decided ex parte, your lordship, the title suit. Earlier, all the proceedings, all the hearings were done by learned civil judge Tage Hale. Meanwhile, he got transferred, and then Harinder Kesab, learned Judge Harinder Kesab was transferred there. Only in the time of pronouncing of the decree, the judgment was pronounced, decree was pronounced by him, your lordship. Hurriedly
entitled to possession by reason of any forfeiture or breach of condition.
Yes.
Your case what? Breach of condition?
Yes, your lordship.
Of what?
Of the agreement, basing on which they are occupying my land. Though this agreement is, your lordship, this was to be contested there, but then I was not allowed because they instantly, before the title suit began, your lordship, they have dismissed the title suit saying that it was barred by the law of limitation. This agreement itself, they are occupying my land basing on this undertaking. And if the
One way you are saying it's undertaking, another way you are saying agreement.
the actually this is an undertaking, but in their
Either it should
judgment
be
they
agreement or undertaking.
this is undertaking. In their judgment, they have said that this is agreement. But as per my, I'm concerned, I'm saying this is an undertaking.
Why you have not been allowed to participate? Why you not been issued a notice? Have you not received the notice?
No, I was the plaintiff there. I was the plaintiff.
Hmm.
But then outrightly, they have said that you are coming after 38 years, 30 years. So this is barred by the law of limitation. So you cannot file this title suit. What I am praying this honorable court is that they have filed a deposition, which shows that in the year 2015, they have partially, partially
Complied the condition.
complied, yeah, the conditions, and they have given me work order. So now this condition number 1 is still remaining, and they had outrightly verbally told me that they are unable to give me land soft license or land allotment. So being aggrieved, I served a legal notice.
Who is occupying?
The respondent number 3, that is extra assistant, is AEPWD. Assistant engineer PWD is occupying.
Office. Is the
Yes.
office of a.
Yes,
assistant
it's
engineer.
part, some portion is office and some portion is a compound area. Your lordship, 3,870 square meters. It is my ancestral land, which was with the horticultural land earlier. On their request, your lordship, since they have sent those days in the year 1977, they had sent 3 political interpreters to request us to donate the land. So accordingly, I had signed this undertaking on the condition that they will give me a separate plot as a land.
You are the
allotment.
legal heir. Legal
Yes,
heir.
I am the legal heir. Earlier,
Legal
my
heir.
yes. Earlier, the case was contested by my late father, your lordship, and the.
When did you file the suit?
I filed the suit in the year 2016.
First, you have to show that it is a reason of forfeiture or breach of condition.
It's a breach of condition, your lordship.
Unless this is an agreement,
Yes,
how can this be breach of condition?
this is they are occupying the land now, saying that it is an agreement, and basing on that they are occupying. So now they are
You are
assuming that it
disputing that this is an agreement. This is not an agreement.
Your lordship, that I was pressing in the title suit, but then they have barred it. And if your lordship intervene and
Let us-
revert back this case to the,
Let's see the.
Your lordship,
If you
if I
know
may. The copy of the plan is not in the records also, your lordship. That I would like to highlight this court, your lordship. Not in the memorandum of value or the records. Copy of the plan, your lordship.
Have you annexed the plaintiff?
no, your lordship,
No.
I have annexed the order only.
It has not been annexed.
Copy of the plan will not be required, I guess, your lordship.
Because it's basing on the plaint only, the Honorable Civil Justice Senior Division has come to the conclusion that the suit is barred by the limitation.
It's in page number 42, your lordship.
Page 58.
Yes, sir.
The appellate, the cause of action arose on so and so on sending of legal notice. That is our inquiry.
Page 58.
Para 7.
Sir, the learned copy of the sponsors. Yes, Your Lordship.
Hello?
May Your
Have you
Lordship.
checked it?
I have checked once, Your Lordship, but
Plain. This also a scan copy.
yes, Your Lordship.
Why not original?
Your Lordship, they had rejected my title suit with the reasoning that I was inordinately sleeping over for last 38 years. Your Lordship, when the condition.
You have amended the appeal.
Yes, substantial question was too lengthy. I prayed for amendment and it was granted.
Heard Mr. You fix it some other day. We'll call for the original records. And with the copy of the plan.
Yes.
Okay. Mr. Heard Mr. R. Rakshablan, counsel for the appellant. And also Mr. Waider of Planet. Still counsel for the respondent. After hearing the learned counsel for the appellant for some time. About. When the records were produced, then records, only record. The record was produced. This one finds that it was the skin copy of the law trial court record. Moreover, the copy of the claim is not picked up. In view the record in original along with the plain copy of the plaint be called for. Christopher. Let this matter be listed after 3 weeks.
Yes.
Romalo.
Yes.
Yes, Your Lordship. Obliged.
Obliged.
Yes.
My lord, I have taken the instruction from my senior counsel.
To argue the matter.
No, my lord. He said it on several occasions, more than 2 times, he argued it already before, but this honorable court did not pass any order. So last opportunity may be given, my lord.
What does it mean? Whatever is there, this court wants you to argue the matter.
This is a service matter, my lord, regarding
Yes.
recruitment in seniority post.
What is the rule? 1989 rule.
Page 29. Page 29.
29.
29 also.
This was the rule holding the field that point of time.
Lordship, yes.
How is where it is? How the seniority has to be determined?
If Lordship come to the Rule 9, Lordship. It says so, the post is LDC here, Lordship. Rule 9 is at page 30, and it says, Lordship, the post of lower clerk division shall be peeled off from the select list prepared under Rule 11 in the following manner, 90% so and so. Then, if Lordship turn to the next page, this Rule 11. Rule 11 says, Lordship, the procedure for preparations of select list, how the select list has to be prepared, Lordship. The appointing authority shall refer to the commission or the committee the approximate number of vacancies likely to occur in each of the categories and furnish the commission or the committee with the character roles and other detailed particulars of all eligible candidates. The appointing authority shall also specifically indicate whether there are any vigilance or departmental cases pending against any of the officials whose cases are eligible to be considered. In the case of post to be filled up by the direct recruitment, the records of the written examinations, etc., will also be produced to the committee. The commissions of the committee shall examine the character roles and other relevant records, taking into consideration the seniority cum merit of the candidates and prepare a separate list of names in order of preference for recruitment to different categories under Rule 6, 7, 8, and 9. 9 is of the Lordship LDC. This list shall be forwarded by the commission of the committee to the appointing authority. The appointing authority shall consider the list prepared by the committee along with the character roles and particulars of the candidate and approve the list unless it considers necessary to make any change in the list. If the appointing authority consider it necessary to make any change in the list received from the commission of the committee, he shall inform the commission of the committee of the changes proposed and the reasons therefore, and after taking into account the comments, if any, of the commission or the committee may justify, approve the list finally with such modifications, if any, as may in his opinion be justified and proper. After obtaining the clearance of the personnel department, the list finally approved by the appointing authority shall form the select list for the purpose of appointment under the apposite rules. This rule 11 talks about both the promotional and then lordship direct recruitment lordship. What I understood from this rule 11 is that lordship, while preparing the select list in case of direct recruitment, merit has to be lordship considered to put the list while preparing the list, because on merit lordship there the entry has to be lordship made top, the highest rank lordship as serial number 1.
Yes.
Now in present case, what happened if lordship come back to page 24 lordship? The select list dated 27 March 2002 lordship. In this select list, it's silence whether this select list has been given in merit wise or lordship without randomly lordship.
Yes.
That is not specified in this very order. It's at page 24 lordship, annexure 1. Here lordship, what happened? The petitioner's lordship starts from serial number 2, Tagedon. In this list, their name appear lordship before the private respondent lordship. But actually what happened lordship, the private respondent secure more mark than the petitioner here lordship.
In the exam.
In the exam lordship.
Selection process.
In the selection process lordship. And this selection was done in district based lordship. Suppose say for Lower Subansiri lordship, quota was specified and candidate was called from that very district or against that district only lordship. And selection was done as per the merit secured by them in that particular district lordship. Therefore, lordship will find, suppose say one has secured 100 in lordship Lower Subansiri and other one has secured lordship 200 in lordship Papumpare. Even if he secured lordship 200 in Papumpare lordship, he will not be selected lordship. But in Lower Subansiri, if among the lordship merit, if one has secured 100 also, if he comes to top in that particular district lordship, he will be selected. But in Papumpare, though he secured 200, but before him, another 3 persons against that quota, the marks secured by them are more than 200 lordship. Then those candidates would be selected. But this person who is behind them, though secure more than the lordship, the rank number 1 secured in the Lower Subansiri district lordship, he will not be selected lordship. So because this is selection
What
was
is the system of selection?
lordship, there was an advertisement lordship, and in selection lordship, it has to be done from the district lordship against the
And then
district. quota.
centrally you will prepare.
Yes,
the
it was
select list.
divided among the district lordship.
Then this appointment select list will be prepared by.
After selection lordship, the
Prepared by the centrally prepared. this
lordship, centrally prepared lordship. So what petitioner is claiming lordship? As per the rule lordship, on merit lordship, the list was prepared and his name comes before the private respondent lordship. But the extent of the department while preparing the lordship seniority list lordship, seniority list was prepared considering the merit in that selection process lordship.
Because this selection list, this appointment and selection list is not based on merit.
Not based on merit. That's our extent lordship. Just for example, lordship, if lordship take up my lordship affidavit, just here the petitioner number one, Lordship. My affidavit, Lordship.
Yes.
Petitioner, he number one, Lordship. He
Your
appeared against
affidavit
that
is Page,
page, Lordship, 34, Lordship.
huh?
Page 34, Lordship.
64.
Page 34, Lordship. My affidavit, Lordship. Affidavit filed by respondent number 1 and 5.
34 is something different.
Is annexure 2.
This is schedule of the rules. 34.
This is the affidavit in opposition filed by respondent number 1 and 5, Lordship.
Yes, Lordship. Additional affidavit on behalf of petitioner.
Not additional affidavit, counter affidavit.
Counter
Affidavit
affidavit.
of opposition. It's not affidavit, this is writ petition. This is writ petition. Huh? There's no affidavit.
Four 35. Yeah. If Lordship see the page 34, this is the selected list from the upper Subansiri, Lordship. It's from upper Subansiri. And petition number 1,
They are all,
Lordship.
petitioners are all upper Subansiri.
No, they are from different, Lordship. Petitioner number 1 is from upper Subansiri at serial number 1, Lordship. Tagedon. He's a petitioner number 1 here in this petition, Lordship. If Lordship will say, he's secure 191 total marks, Lordship. From upper Subansiri, only two candidates have been selected because 2 was quota was, Lordship, assigned to the upper Subansiri. Here, Lordship, the first and second, 191 and serial number 3, 186, Lordship. They have been selected from the upper Subansiri, Lordship. Here, what I'm pointing out is, Lordship, from upper Subansiri, the mark secured by Tagedon petition number 1 is 191, Lordship. If Lordship turn to next page, Lordship, page 35, Lordship. This is from East Kameng district, Lordship. Here, Lordship will find serial number 1 Rani Kamsa.
229.
229. She has been selected at first, Lordship, from East Kameng. Then serial number 2, Yago Tajio 228 second. And third is so and so. And Port Lordship Mani Taku. Mani Taku secure, she secure 199. But she was not selected. Because quota mean for the Lordship is coming was only the Lordship 2. So therefore, Lordship, Mani Taku, though secure 199 Lordship, which is more than the marks secured by the petitioner. Because petitioner secure only 191 Lordship. Mani Taku secure 199, but she is from East Kaming and he is from Upper Subansiri district Lordship. And this quota was already specified for the district Lordship.
So taking into the respective marks in the exam, you have a combined seniority list.
Combined Lordship. So combined Lordship selection list was prepared Lordship.
And the selection list which they have based is on random, not on merit. On merit.
Yes, yes. Not on merit Lordship. Though, because combined selection was Lordship, selection order was prepared, which is Lordship in the writ petition.
Where does it say that in the rule that it should be based on merit or select list?
Select list Lordship will say in the rule Lordship. Rule, kindly come to rule 11 Lordship. It's say order of so and so.
No, order and other 11 records taking into consideration seniority come merit of the candidates and prepare separate list of names in order to. No, rule 11 talks about the for appointment. It has to prepare on merit wise.
This is rule 11 is pertaining to procedure for preparations of select list Lordship. How select list has to be prepared Lordship. And if Lordship come to the rule 14, appointment may be made from the select list in order in which names appear in the list, provided that a temporary appointment for a period not exceeding 2 months may be made by the appointee at his own discretion. The petitioner is taking advantage of all these Lordship, provision Lordship. Here Lordship, where you are appearing in the select list Lordship, seniority has to be maintained as per the.
They are plainly based on the select list. Based
Yes, yes, they are there. And it's admittedly Lordship, the petitioner secured less mark than the private respondent Lordship. It's not disputed Lordship. As a matter of Lordship, principle also Lordship. Obviously Lordship, in one selection Lordship, those who rank higher Lordship, their seniority will be there only. When equal Lordship, then age determines Lordship.
That is what he is trying to project. But it said as per this recruitment rule, because they are relying on this this page 24. Appointment order or it's a select list.
This is the Lordship. This is the Lordship.
Who have been endlessly beneficiary hereby appointed on and so.
This is appointment order Lordship.
It doesn't indicate what the merit.
Lordship. It does not indicate Lordship whether it's in merit or Lordship otherwise Lordship.
Because the rule also doesn't provide that it should be based on select list.
Lordship.
It doesn't, it only provides
Lordship.
that the select list shall be prepared as per the merit.
Lordship.
Recommended by the committee or commission.
Lordship. But that was
if
not.
there is any change, if they don't agree appointing authority, they may have modified
Lordship.
it.
That part
subject to approval by the committee.
Lordship. And that part was not complied by the authority. That is there.
They have just run
randomly Lordship. Whereas Lordship, it should have been on merit Lordship.
Okay.
There's an omission on the part of the authority.
Last opportunity will agree.
No issue Lordship.
I wanted you to argue the matter. Heard, Mr.
M. Kambo.
Learned counsel for the learned counsel appear on behalf
On behalf of
Mr.
Mr. R. Sonar.
R. Sonar.
Yes.
Learned counsel for the petitioner. Who submits that? No, please stop. He submits that the senior Mr. Arsenal has not permitted him to argue the matter. Rather, asked, they instructed him to pray for adjournment so that he could appear and argue the matter, for which he prays for listing the matter on after 3 weeks. It's 2 weeks or 3 weeks. 3 weeks, Mr. Estapin, the senior government advocate. It's present accordingly. Since the leading counsel, Mr. Arsenal wants to appear. Now, with the matter, come on. Though the matter is and having considered the matter is of 2015, then the matter will stay after 2 weeks as a last opportunity. Hearing, huh? As a last opportunity. This